Good evening, everyone. I'm going to call this meeting of Planning and Zoning to order. Thank you all for attending this evening, especially since it's a special call meeting this evening. We are going to start by taking roll call.
Steve Thomas.
Here.
Tim Dooley.
Here.
Holly Rickert. Tom Musselman.
Here.
Cindy Scroggins. Jeff Lawrence.
Here.
Daryl Whitworth.
Here.
Jim Giroux.
Here.
Janice Menking.
Here. Thank you. And Jeff, you're going to need to recuse yourself, and Cindy Scroggins and Polly Rickert are not in attendance because of their conflict of interest. So we do have a quorum, and we're going to get started. But before we get started on this meeting, I know that everyone here is here for have very, very personal reasons for or against what we're going to talk about this evening. I just ask everyone to respect everyone else's feelings. And this is a wonderful community, and we all have this wonderful community because everybody respects each other and we work together to get to where we need to get on this issue. So I expect everyone that when someone's on the podium that you respect everything they say, and I respect everybody here and all the staff, and we're going to have a wonderful meeting and everybody will feel good about it when we leave this evening. So with that said, we're going to go to item number 3, public hearing and action. Number A, request Z 2318 to consider proposed amendments to the city zoning code regarding short-term rentals. And the method we're going to go by tonight is staff will make presentation. So they will go through the new changes to the ordinance. Then the commission up here will go through those changes and make comments on have questions for it, make comments on it. Then we will hold the public hearing. So if any of y'all would like to speak for or against this, there are forms in the back, and we'd appreciate if you'd fill those out. So we have your names, and then we will start calling your names to come up. We will give you 3 minutes to speak, and Mr. Giroux is our timekeeper. And after everyone's had their chance to speak, then we will go out of public hearing, and the commission will then take action on the items and make recommendations to city council, and then they will have another public hearing on this issue. So anybody have any question on that process? All right. We'll have presentation by staff and the commission. If y'all will hold your questions till after they're finished, give them a chance to go through all of it. No, public hearings later. So staff, if you would make your presentation.
Good evening, Chairwoman and ZB or Planning and Zoning Commission, and to the public. Thank you all for being here. This is obviously a very important issue for the community, and nothing that's brought us together more often than short-term rentals. So I want to acknowledge some of the staff that's in the room that's usually not up here at the dais with us. From our finance department, we have Janelle Chapman and Darren Eckhart. They are both over the hot hotel occupancy tax. Janelle was doing that exclusively until we were able to hire a full-time person. So if you've received a letter recently, it was from Darren. And then I also want to acknowledge that our STR specialist, Jan Musgrove, is in with us today. So she is the person you've been dealing with on since November. This is all she does is short-term rentals. God bless her. And then, of course, Shelby Collier, who was doing that but prior to Jan being hired, and so has able to take less and less of a role and only handling those really complicated STR permits. So, and of course, our assistant city manager, Garrett Bond, who was here in my seat last time we did this. So Anna Hudson, Director of Development Services, and we've got a draft ordinance for you tonight. It is definitely a draft that has been drafted by our legal counsel. Miss Rachel Raggio is here with Toast, who's our city attorney. She's down from Fort Worth. She's met with us before virtually, so you may recognize her face, but we're very glad to have her here and in person, and very capable of answering questions that you have, very specific or high level. So looking forward to a robust conversation this evening, but this is a draft ordinance. Nothing has been set in stone by any means. This is a continuation. This body has met with City Council multiple times in joint deliberations, And so this is a result of those prior meetings. And that all started because the mayor called a task force, an STR task force. And that task force included people from the Neighborhood Coalition and the STR Alliance, and was a good representation. So that group gave a presentation in March. And since then, we've met again multiple times to kind of go through recommendations that they presented, and then it's evolved ultimately to this document. If this board decides to take action, which we hope you will, because this has been noticed as a public hearing tonight, and then the follow-up public hearing would be for city council. Usually they meet within 2 weeks of this board. But knowing this we anticipate changes, so we pushed that meeting to October 3rd. So that's when City Council will take up their recommendation. So all that being said, I want to kind of go through the memo that staff presented. There's some things that staff's recommending, some things we're just giving you information, not really taking a stance on some things. But here, obviously, to answer any questions you have, this is a very complicated process. It involves planning and zoning. It involves the building department. It involves finance. It involves code enforcement. It involves PD. It involves municipal court. So it's a complicated and complex thing that we are trying to deal with. So the letter that went out to the property owners had some of this language, and I will say, if you received that letter, there was bold 14 font type that was required by that the state required us to print about the non-conforming, because there was a new state bill that was passed this legislative session regarding non-conforming. So some of that language was state mandated, even though it didn't quite apply. So this was a summary in that letter about the proposed amendments to repeal the existing short-term rental ordinance and shift the majority of those STR regulations to Chapter 20 of the Municipal Code. So highlights from the amendments that we will go over include clarifying and updating the regulations to apply to all STRs, to create specific enforcement structure for repeated major STR violations, and to create new appeals procedures related to STRs, and to clarify procedures for transferring and renewing permits, and to establish that certain types of STRs may continue to operate as legal non-conforming. So I've already given you the background, how we got here. Again, this was drafted by the city attorney with input from staff based on those prior meetings we've had with city council and P&Z. Today, there are currently 1,058 active STR permits within the city limits. And I hope everybody's been able to get to the interactive map. We're very proud and glad to have this map available now. So it's on the city's website on the STR page. And so you can look at this entire city limits with the zoning and see the location of all permitted STRs. Now this map was accurate as of August 1st. So it's not tied directly to our database, or we don't have a database, but our Excel spreadsheet. So we will ask our GIS third-party consultant to update this monthly. So we're going to ask them to get numbers accurate for September. But as of August 1st, these are the accurate permits. So those orange blocks, squares or shapes, those are active STR permits. So staff is recommending amendments to the ordinance to address ongoing issues and provide additional clarification for future permitting, remittance of hotel occupancy taxes, and enforcement. However, prior to adoption, staff suggests further discussion on some of the following topics. So I do want to go through just some data that we have, because all along when we were trying to do this ordinance in 2022, we didn't have a lot of actual data. And since that time, because of staff's very, very diligent work, we have what we think are pretty good numbers. The newer the number, the more sure we are of it. Back in 2018, there were no different types of STRs. There was just one type of STR. And we didn't really track by district. But You can see how the number of STR units, again, units means an individual permit, not a structure. Um, and then by R1 zoning, so you can see that it kind of peaked in December of 2022, and then more recently we're down to 523 in R1. A chart over time from 2018 to 2023, again peaking in 2022. And that's, I will note that when we did the 2022 adoption, we adopted an ordinance the same day we switched software, which is very problematic for staff, transitioning from one software to another. And so there was probably some duplicative permits that were processed under one or pending in another software. So that may be a little inflated, but those are the numbers we have. This is STR parcel versus STR unit data. So a parcel is from GCAD, the appraisal district. They give every parcel an ID number. And on a parcel, you could have multiple units, especially in R2 or CBD or C1 zoning. We tend to see multi-units on a single parcel. We'll note that there were 48 R2 properties that have multiple units on one lot, and those do not include condos. Here we have some numbers of permit type by zoning. And when we created the 2022 ordinance, we essentially created over 1,000 non-conforming STRs. So now as renewals come in, Jan is then categorizing them as, is it an unoccupied, is it a facility, an accessory, or B&B? So those numbers look really low because they were not tracked prior to 2022. And here's an occupancy count by zone. So you can see like in R1 zoning, we have 102 properties that have an occupancy of 4. So the occupancy is across the top. The number of units is here. So within the city limits, we seem to have an occupancy of 6,047 people in our STRs. And that's across 1,058 units. And this was just a map kind of showing the STR units over the zoning map. So if we go by topic,
I'm sorry.
if we go by topic, the biggest topic, one of the biggest topics was non-conforming uses, just because the state also changed the rules on us as we were literally in the middle of going through this process. But the 2022 ordinance does allow for non-conforming uses to continue operation. It also allows renewals and it allows for transfers. The proposed draft requires renewals to come into compliance. We do think this will cause some issues, especially if a renewal were to come in and have to meet with all the new parking requirements. And we'll go through all these things. So non-conforming, we might just want to kind of keep in the back of our mind as we go through these other topics because it's woven in there. But staff does suggest allowing non-conforming status to renew, but to come into compliance with the life safety requirements, such as smoke detectors and host rules. And so that would require inspections at renewal. Again, it's going to bleed into these other things. So one of the things we've heard a lot from neighbors is parking. Parking is definitely the biggest complaint that we get. Concern that we get from neighbors is, oh my gosh, this house has 10 cars in the driveway and spilling out into the street. And of course, Fredericksburg has on-street parking and it belongs to no one but the city. And so anyone can park on the street, and as long as they're not in violation of the parking requirement, blocking a fire hydrant or blocking someone's driveway, then it's fair game, right? So we can't restrict it. Just like we can on Main Street. Anybody can park in front of your business on Main Street and anybody can park in front of your house. So the 2022 ordinance, let's go back. The 2018 ordinance only required 1 spot per unit, which was obviously problematic. If I had a magic wand, we would fix that. But that's how the 2018 ordinance was written. And of course, a lot of permits were issued under that with just that basic requirement. The 2022 ordinance did require parking per bedroom, but it gave credit for on-street parking. We don't give credit for on-street parking for any other use in any other category. So this was an anomaly, and it makes it difficult for staff on the permitting side, and it's just treating an STR differently than any other use in the city. So staff's recommending that we remove that from the current ordinance. And then all other required parking is per bedroom and should be on site. The current draft speaks to tandem parking and proposes limiting that to 2 deep. This has also stirred a lot of conversation, and if it's multi-unit and there's multiple guests that don't know each other that might be parking in tandem, that could be problematic. But if it's all on one site, they're all of the same party, I guess that's their problem to deal with, because we do know that some of the lots in town, especially the historic district, are very deep, right? And you can literally fit 6 cars in a row. So staff could support that change of allowing more stacking for tandem, again, as long as it doesn't block the right of way. So transfers, the 2022 ordinance does allow transfers. It requires them to be completed within 10 days. The rationale behind that is the same as with your utilities. If you buy a property, you got to transfer the utilities over into your name. We wanted the STR ordinance to be dealt the same way. If you're taking responsibility for this business that's being operated, you're responsible for HOT, you're responsible for the utilities, you're responsible for the people in it. So that was the rationale for the 10-day. The current draft doesn't say it specifically, so if you read it, it may have been a little confusing, but it doesn't say 90 days. It says in conformant or in line with the non-conforming use status, which is 90 days. And so staff would suggest that we treat all permits the same as far as transfers. I know there's some conversation about maybe not letting new permits transfer, but again, that could become an administrative nightmare for staff. And so again, you've got to realize staff's dealing with the 2018 ordinance, the 2022 ordinance, and then 2023 ordinance, I guess we'll call it. And so anything that can be streamlined that we can treat the same is fewer options for something to happen. So inspections are another issue. Right now, they're required for new and renewals if there's an alteration. If it's changed that all renewals must comply with the life safety minimums, then there will be a large increase in the number of inspections and possibly impacting the need for new staff. We currently do about 10 inspections a week, and that's doable. It's manageable with the code enforcement staff that we have. But if we do something to change that, I think it could have an impact on our budget. Special exceptions, this is a new concept that Rachel brought us. Other cities are starting to use this as a way to deal with short-term rentals. We currently use the conditional use permit, which requires planning and zoning recommendation to city council, so 2 public hearings. The new ordinance creates this special exception. Those would go through the zoning board of adjustment, and it does specify some new criteria that they would consider. And it goes through some of the reasons that someone could apply for a special exception. R1, the biggest difference or the biggest impact the 2022 ordinance had was to not allow any more new unoccupied in R1. And that has been effective. That the numbers show that as you look up at them over time. There were a few that, we definitely saw a rush right before the 2022 ordinance was adopted. We call those panic permits. It was definitely a rush to new permits in R1. But just this week, Jan told me that she had 7 to 10 after the hot letters went out, for compliance, the people withdrew them. They decided it wasn't worth it. So, the R1, the 2022 ordinance has been effective for stopping the spread in R1. when the 2022 ordinance was written to allow these stranded properties a chance out, right? So if you were truly stranded, nobody would want to live in your house if you tried to sell it because it was surrounded by STRs. We wrote it in such a way that if you had two adjoining lot lines and 75% of the block face were STRs, then you could apply for a CUP for an unoccupied in R1. Well, to date, no one has met that qualification just to even be able to apply. So you've not seen any CUPs for R1 unoccupied in the year plus that the 2022 ordinance has been enacted. We've received one variance application, but it's not been sent to ZBA yet, so we're not sure the outcome of that yet. So the current draft, it changes that language to 75, moving away from the block face to 50% within 200 feet. So this 200-foot circle that we use for all of our public hearings, our notifications, staff would like to see that used more consistently and get away from this block face or block, because a block in Fredericksburg can be 15 houses or it could be 3. Very inconsistent. So however you decide to deal with R1, I know there's definitely concern from the neighborhoods about allowing that creep of more STRs into the R1 neighborhoods. So if you want to allow that option out, we would suggest moving to a 200-foot radius, put whatever parameters you want around it, but using something that's consistent, like 200 feet, 500 feet, whatever, but not a block. R3, the 2022 ordinance does allow them an R3 STR permits. The current draft does not change that. We've heard a lot of conversation around that, and staff could support limiting permits in these high-density multifamily R3 districts, of which we have very few, but we do want those to be used for multifamily. So we could support making that change. Condominiums, the 2022 ordinance allows STR condos with a CUP in certain zones. So there are no STR condos by right. They all required a CUP. We had a lot of condos that were vested and approved before the adoption of the 2022 ordinance, and then they completed the construction after, and so they were allowed to come in under the old. Since the 2022 ordinance, no STR condos, I believe, have been approved with a CUP, and the current draft removes the ability of an STR condo permit. If you want to talk about R2 density, we can do that. We've got the map. We've just heard, about certain neighborhoods that are feeling saturated, and R2 by right allows one unoccupied. So any R2 unit or lot could get at least one unit. So let's see. And then enforcement, of course, is of something to discuss. This is a change. We're proposing minor and major violations, separating those, and then 3 minor violations would equal 1 major. 3 majors within 12 months would send a permit to City Council. So the director would have the ability to send that permit holder to City Council to consider suspension up to 90 days. And then the appeal of a permit denial would be sent to City Council. So if the director were to deny a permit for some reason, the appeal would go to City Council. And council would have the ability to revoke or suspend a permit with certain requirements. That's the majority. You can ask any questions. We can show you stats, numbers, maps, whatever you desire. Rachel, I don't know if you want to talk a little bit about. We've had a lot of questions about vesting, and grandfathering, and vesting and grandfathering. So if you could maybe just give a legal explanation on grandfathering, non-conforming, and vesting.
Okay. So I'll keep this very broad and simple for now, and then we can get into specific questions as they come up from you all. Vesting, or excuse me, well, let's refer to it as non-conforming uses. So it's very important to preserve the rights of non-conforming uses. To that end, this ordinance works very hard to preserve the ability of operators who are currently operating their short-term rental to be able to continue operating that under the new ordinance if it is adopted. They, with the current draft as proposed, they would be required to come into some compliance with some requirements, like the life safety requirements in particular. But when it comes to things like, as Anna discussed, the parking, things like that, there may be some room for us to give them a little leeway there, because we want to preserve their ability to continue operating if they've been lawfully operating to date. Lawfully operating would be, lawfully having a permit, remitting hotel occupancy tax in accordance with state law, things like that. Anything else you want me to? It is, yeah. So grandfathering, yes, that is a real term. But we will typically refer to them as a non-conforming use. But I think grandfathering is kind of the common layman's term. So when we talk about non-conforming uses, we are talking about grandfathering. When it comes to short-term rental properties that have submitted an application but were for some reason denied, and they may have lodged an appeal with the city manager's office, those properties, they're not technically grandfathered, but their application is grandfathered in the sense that we'll consider it, but we'll use under the current draft, we would use the provisions in the new ordinance that govern appeals in order to give them complete due process rights, preserve that concern, and essentially give them their fair shake at getting a short-term rental permit, if that makes sense.
All right. Thank you very much for that. And for those of you all that like those statistics and want to see them, that is on the city website. If you go to the city website and go to agendas and minutes and go to tonight's meeting and go to the packet, all of these statistics are in there and you can look at them and have access to those. All right. Thank you, Anna, and for the information. Well, now what I think we ought to do is go item by item, and you can ask questions and make comments accordingly instead of just randomly going out there. So let's start with on page 4. Mm-hmm.
Good information, and I'm really glad
Right.
to see we're trending in the right direction. That's what we all hope that. I said good information. I'm glad to see we're trending in the right direction that we had hoped to go into. But I really think I'd like to see some violation numbers. Are any of those anywhere around?
For the purpose of seeing if the existing ordinance is working.
That.
Or how the existing ordinances work since April 22.
Everything ending up on the test. Where's that process going? None of us really fully understood it to start off with. So, any clarification on that?
So code enforcement moved over to PD, and talk amongst yourselves. Let me try to pull something up real quick, but
Okay.
We'll come back to that.
I mean, it doesn't have to be exact, just a.
Yeah, but it is low. I'm going to tell you it's low.
It is low.
It's
so
very low.
150, 20,
Let me pull it up, but it's low.
Okay. Because it just gives us a little bit of a barometer to evaluate our homework in 2022.
Was the 2022 ordinance effective as it was designed, in spite of Granicus and the lack of information?
In spite of law.
Right.
Okay. So let's go to page 4 under staff recommendation and all the different areas that Anna went over. The non-conforming uses really apply to all the different areas, basically. So let's start with, and I don't think Anna talked about the long-term rentals. Does anyone have any comments or questions about the long-term rental area? So this is something that is allowed right currently, and basically you're just adding more language to clarify that on allowing people to take their short-term rental out of short-term rental and make it a long-term for a period of time.
Correct. The current draft would allow that. They essentially just need to put staff on notice that, hey, I'm converting this to an LTR. So I think some of the language we want you to clarify is there a time limit on that? Is that indefinite? Do they need to keep up with staff every year and report, or keep a current permit, or they can just get it back whenever? So I don't think we would want you to fine tune that, but staff's definitely supporting making it easy to go to a long-term rental and come back to, to be able to hold that ability.
Anybody have any comments?
I
recommendations?
have a suggestion for the verbiage on that type of thing, if you will, please. It says, if an owner chooses to continue its STR permit while long-term renting property, said owner may renew without interruption STR permit, provided all permit fees, hot tax quarterly filings, and all required inspections are performed.
So basically, if you have an STR and you decide that you're going to long-term rent it, or you're going to live in it yourself, as long as you keep up your STR permit up to date, as long as you file your hot tax form, even if it shows 0 tax owed, and you keep up your inspections and your permit fees, then the permit continues until you decide to either not long-term rent it or not live in it, or voluntarily give up your permit.
So if you said something about in perpetuity, yes, that is exactly right. And that is, in my opinion, that's kind of the intent if you're doing everything.
90-day revenue report, for revenue, 90 days.
No.
No.
That's not conforming.
Well,
If you don't report revenues,
90 days in the current ordinance.
but that's your STR filing. You have
That's
to
a
do that
filing.
even if you don't.
I mean, we
That's
don't.
not the way the ordinance is written. The ordinance is written that you don't submit.
So we're going to
revenues on
penalize.
short-term.
We're going to penalize an STR owner for having an STR that nobody rents. Okay.
For winter taxing
So I mean, I could see the fairness
I
of.
just don't know what she's talking about. The provision addresses that's on the two statute that's requiring the 90 days.
So the current draft that we're looking at tonight proposes to essentially put enforcement of that abandonment of use on hold if they notify the city that they're going to operate as a long-term rental.
Okay.
So so they wouldn't lose their permit for operating as a long-term rental. It's a way to preserve that ability.
Perfect.
And I think what Mr. Dooley was saying is that in order for them to preserve that, in addition to notifying the city that they are turning their property into a long-term rental, they also need to file the appropriate forms to show that they don't owe any hotel tax, that they keep up, that they also keep up the everything they have to do to operate an STR. Is that correct?
Yes.
And you're saying in perpetuity?
Well, it's implied.
So if I may,
You may.
what I'm hearing is you agree with a short-term rental operator converting to a long-term rental conditioned upon them renewing the permit every year and filing a 0 hot remittance every quarter.
Yes, ma'am.
That preserves their permit. And if they don't file, the permit goes away.
Okay.
Or it goes through the process.
Or it goes through the
They
process
send a letter
again.
out
Right.
citing all
And I think it's important, and this is something that needs to be discussed now, is the inspection portion of that. Because I don't know how often are STRs required to be inspected, once a year?
So under the 2022 ordinance, under the ordinance today,
Yes, ma'am.
if you file a renewal and you're the same owner, and no changes have occurred to the property, you haven't modified the building in any way, and no complaints have been received, you do not need an inspection.
So
That'll work.
So I would say that once they go back to a short-term rental, it require an inspection.
Absolutely. Yes.
And again, to make sure I'm understanding correctly, your recommendation would be that that's in forever.
Can be, if they follow the rules.
Yes, sir.
Any other comments on that section? All right, parking. This is your big one. So, anybody have comments on the parking? The current draft removes the on-street parking credit and limits tandem parking to 2 deep. Comments on that possibility of removing that?
My suggestion on parking would be to, I'm looking at and on page 18 of the draft, section 7 on off-street parking, it says, the way it reads is tandem parking is allowed for a maximum depth of 2 vehicles as long as no part of any parked vehicle obstructs a public right-of-way. I would suggest that we change that to tandem parking is allowed for multiple vehicles as long as no part of any parked vehicle obstruct a public right-of-way.
The only other factor could come in is impervious cover regulation.
Okay, if they don't, and I thought about that, we're taking away credit for on-street parking. There are some properties that are going to have the ability to widen a driveway.
Yes.
Okay, as long as they continue to meet setback requirements and impervious cover requirements, why can't they widen their driveway? I see this as a way to increase parking and to get parking off the street, which is one thing that we're trying to do.
So y'all mentioned earlier that private individuals can park in front of their home, but I know of at least 2 communities where STRs are not allowed to park on the street. How did they get around that? Port Aransas is one of them. We have to have on-site parking there. So
Do they require a parking pass?
they don't require parking pass. They just require that all parking is be on the property.
I can speak to that. So more than likely, in those particular communities, there may be deed restrictions. There may be homeowners association regulations, and we can't do those same kinds of things. We can't interfere with that. We can't tell HOAs what to do. So that is up to the homeowners association or property owners association in that particular area.
We have so few of those. I'm just talking about general parking. Like Travis Street, also. Yeah. I don't want to restrict on-site at all. I don't want to make impervious cover level. Also, there's a more on-site. I'm not going to violate the street.
Well, here's the issue that I've got with the tandem is if an owner has the ability to increase the size of the pad where they can increase the number of parked cars from say 2 parked cars to 4 parked cars, then without violating the impervious cover rule, it's like adding to the width of your driveway. I see that it's within guidelines, zoning guidelines for I guess maximum density per. I guess is that the impervious cover maximum density per lot?
So the maximum impervious cover will be dictated by the zone,
Right.
and it would include all building cover and non-permeable surface.
Right. So if you can meet that and increase your parking, then that's good for you. If you can't, then you need to look at some way to reduce your occupancy.
So where I was going with this is that instead of allowing it, we require it, because probably no self-respecting business owner building is going to be parking unless required. So that's kind of what I was thinking, so they would still be getting to sleep on the street.
Well, the problem I see there is if we say you have to, we're giving you a way to increase your parking. And if you don't increase your parking, you don't have the ability to use the street. Therefore, you can't advertise a higher occupancy than what you can park.
Gotcha.
So,
Is that legal?
Yes.
Thank you.
so a lot of the questions that we're getting in some of the letters,
Wide apron that lessens the street.
Well, that's another option.
There are limitations to the width of a driveway apron. That's within the zoning ordinance as well.
Oh.
In some of these properties, you can stack more than 4 cars.
May I say something about stacking for just a moment? Also, in the example that we were given about parking 4 or 5 cars or stacking two, and two, if and there is some conflict if you have multi-units within the complex that are rented to different people, and then how do they decide who's going to get to park wherever? My attitude is that's not on us, that's on the owner. They got to figure that out. I mean, we can't do that, but and the other thing is I wanted to ask, somewhere in here I read about is the term improved surface for parking? I know. Granite gravel, just regular base material.
So yes, that relates to dust and mud and trying to prevent that from getting on the street. So
Okay.
it does need to be an improved surface. In the 2022 ordinance, impervious or crushed granite is now considered impervious cover. And that's a change from previous.
Yes,
ordinance.
okay. Very good, thank you.
You have to change all of them.
Correct.
so some of the comments that we got back on from some of the letters were concerned about the fact that we're saying that short-term rentals can't use off the on-street parking, but people who live here can, and we're treating them differently. How do we answer that legally? I mean, Rachel, is there?
So what the ordinance is requiring is a certain number of parking spaces per, I believe, bedroom. There's not a prohibition on parking on the street because that's very difficult for PD to enforce. So we're approaching it from increasing the parking stock on the actual STR property in the hopes that that will mean that the street parking issues are alleviated, if that makes sense.
We're not saying they can't park on the street. We're just hoping they provide, we're asking them to provide enough internal. All right, do y'all have any, we'll make recommendations later. Any more questions?
I just would like to remind the commissioners that last night we unanimously voted down a business that met all criteria, had all necessary off-street parking on a parking issue alone. So we have already dictated that we are very concerned about parking for businesses in residential areas, and it would be exceptionally hypocritical of us to waiver now at this point.
Okay. Then let's go to occupancy. The current draft proposes occupancy at 2 people per bedroom plus 2 with an overall occupancy of 12. And previously, the occupants were defined at anyone over the age of 18, but now everyone is included in that, in the new one.
AJ.
Thinking.
Do we have a feel whether like that, 18 unit, am I reading that correctly? That's one of them.
Yes, sir,
Do we
one
have
in
a
our
feel
one.
that that was a special build project that actually had 8 bedrooms, or was that just?
No, that's 12.
So
12 is
any,
the occupancy on the top.
Yeah, so I
Yeah.
see one that said 19.
There's one
There's
that has
one that has
19.
19.
I'm just curious, I'm trying to figure how much of this is reality.
so the current ordinance limits occupancy to 12. So anything that you see that has an occupancy greater than 12 is a non-conforming permit. And that occupancy was not based on bedroom counts under the 2018 ordinance. It was based on square footage.
So we're technically talking about.
That's an R1. You just counted R1.
I just kind of go with the rest of it.
So it looks like there's a total of 23 properties that have an occupancy greater than 12.
I'm perfectly fine with the 12 maximum, but I don't like something probably. So I don't know what that house is.
Well, that was,
That's like fraternity house. Which one that is. So.
But you want to
But-
join.
but they would still be
Kappa
non-conforming.
Alpha.
It'd be non-conforming.
Right.
It would be basically setting a cap, so.
I'm all for that.
Yeah.
Leave it at 12, I think.
The fact that we've added children to it would be hard if you would make it 8 or 10.
That's right.
Right.
For two
Because-
families to come together.
Right.
If you cut it back down.
And a child is a person. And they do occupy space.
And it's important to note that in this ordinance, we're proposing a special exception, and there would be the opportunity for if one of these 23 properties that has an occupancy greater than 12, they could apply for a special exception to allow an occupancy greater than 12.
And then would that go through CBA or through us?
It would go through zoning board of adjustment, yes, sir.
And would they also then apply for a special exception for parking?
Depending,
It depended if they didn't have
Yes, sir.
parking.
So now this would
Depending on the
only be,
scenario.
if we say that when they have, their permit comes up for renewal, that they have to come in compliance with this.
No, because if they're in compliance under either the 2018 ordinance or the 2022, then they're grandfathered.
Right. Okay.
Yes, but that non-conform, you're gonna have to deal with that at some point, because the way it's
Right.
written, it says that they have to come into compliance. So if you wanna just nix that or make certain things come into compliance, that renewal.
So we have to say on each one of them whether we want them to have to come into compliance when their renewal comes up.
So Jan, just for quick reference, say these 16, 18, 19 capacity, how many bedrooms do they have? Are we looking at one bed for 2 people, or what are we looking at? Because then it goes back to our previous discussion about parking, and if you've got 19 units, you're effectively asking for 9.5, 10 parking spots, which is pretty significant amount of parking.
So unfortunately, this data isn't broken down that way. It was tracking the occupancy per zoning. And then I can also tell you based on the occupancy, whether it's a non-conforming permit in this case. So the non-conforming permit that sleeps 19 is of a house that's of a certain square footage. So it was allowed 19 occupants. I don't know if that's a 5-bedroom house or a 2-bedroom house. The house just had to be greater than a certain square footage to allow that many occupants.
Doesn't mean they're actually booking that many, because some people choose to have fewer because of issues caused by it.
That's correct.
But it could have up to that. Not in our
No, it's one unit that has an occupancy of 19.
Well, we have 23 of them that are above the 12. So
Yes, sir.
All right, so keep that in mind that with each one of these, we need to decide if we want to recommend that at renewal, they come into the non-conforming come into compliance or not.
And that would
And
be,
what the implications of that would be for each one of those non-conforming.
and that would be going to a max occupancy of 12. 5 bedrooms plus 2.
That would be an issue for a lot.
I'm just so that naturally, natural attrition, so we stop it now.
The 12.
That was 12 stops it
Yeah.
now.
Yeah.
And the problem, and let's be honest, the problems have been that we've experienced have been the high occupancy STRs.
Absolute attrition will do this.
All right, any more questions on the occupancy? All right, special exceptions. This basically is talking about the CUPs going away, and that will go through the new process, and what not the CUPs, but go through the Board of Adjustments. Anything here really to talk about? Any action that has to take place on this special exceptions section?
That's on. Is that on page? Oh yeah.
Is that something that we have to approve or recommend that we start using special exceptions? Is that the only thing it would be? It's just to recommend
Right, because it is new.
replacing
This-
the CUP process with special exceptions.
Then on page 11 of the ordinance, where it says special exceptions available, could we put in parentheses after that cup or conditional use permit? Formerly cup. I'm looking at the ordinance on page 11.
The title.
Title, where it says section 20-223.
Or are we trying to get away from the word cup?
Yes, and just overall, this is a repeal and replace document, and that's why it looks so
So we
difficult
need
to
to
follow.
change terminology just to keep the versions
Special exception. Okay.
different. Pretty much.
No, it's a new process. I mean, it's taking it out of your court and putting it in the zoning board of adjustment. So it's something new that's created. We don't even, I mean, it doesn't exist right now. The ZBA has never done a special exception at all. So they'll get training on it with the new criteria. I see what you're saying. I mean, I don't think we'd actually put that language in the ordinance itself, but that is what it is.
Is that what the lawyers tell us?
It is.
Yes, and it is. It costs us $300.
Okay, the other thing in this section is under number 3, the R2, the R1 zoning district, and
What page are you on, Tom?
we're on page 12.
Oh, yeah.
And the 50%, this is, I personally believe that we need to keep the 75% instead of the 50%. If you want to do the 200-foot notification area, that's fine, but I think it still needs to be the higher. We had quite a heated discussion over that when we adopted the 2022 ordinance, and the will of the council at that time was that 75% protected neighborhoods more than 50%, and I think we need to raise that back to 75%.
So what's on the screen is R2, but if, for example, this is a real situation, so in your mind, if color it green and call it R1, so if this property owner were to request a CUP, what was a CUP now, a special exception for an unoccupied, and this is how it would drop, that is a 200-foot circle, so then we'd be looking at properties within that. So you were saying more than 75% would have to be.
Well, and the other thing in the 2022, we had the discussion, and it was the lot lines and the number. It was 50% of the houses on the block, and then we upped it to 75% of the houses on the block. If you want to go back to 75% of the houses on the block, that's fine. I understand why you want to go to the 200-foot notification. I'm just.
The only problem with this change, or at least the way I see it, is this is actually would be a more liberal interpretation of the regulation. Currently, right now, they have to touch. So it's the donut rule. We really can't even apply unless it fits into that
because
This could be everything on a piece of property here and nothing on the next street. Again, this looks like we're taking a process we use for other foods or for other zoning notifications, and we're trying to stamp on top of something that actually right now is pretty tight, and this is, unless I'm interpreting it wrong.
well, the other interpretation though was not the 200-foot notification. It was actually blocked. And I understand the issue that staff has because we don't have uniform blocks in this community.
Right.
Okay. And that was if you've got a block and you know, here I'm on Travis Street and
I think we're talking about two different things. You're talking about notification versus qualification. So you're saying, I think the way I read this right is that currently right now it has to touch 3 property lines. And if this is going to be the new criteria to qualify, this is the way.
Jim, the current draft says 2 property lines.
2 property lines.
The property shares 2 or more property lines or 1 property line per corner with a property lawfully operating as an STR unoccupied use. And more than 50% of the properties within 200 feet radius are lawfully operating. And then they can apply for a special exception.
so
And then all the criteria fall into place.
I got you. Okay.
So it's, yeah.
so with that I think 75 is probably the way that we need to go. At least that's my recommendation.
I think 75 is more restrictive, and that's fine. I mean, as you said, we've never had one. So it's not.
The idea, that's why 75 was put in R1, is to limit, and it's done a good job of doing that.
Yes.
How many, just off the top of your head, how many homeowners have you had come to you that could not sell their homes who did not qualify for the exception because of the 4 houses on a block or 3 houses on a block?
So there have been several, and most recently you've considered some applications like I think 204 North Elk was a property that we have consistently discussed because it's in that scenario. The block length is not large enough and doesn't have enough activity on that side of the street for that particular property owner would be a good example. And that's another example that we're seeing is you can have a block full of short-term rentals across the street, but on this side of the street, if there's only one, they can't take credit for the activity that's occurring on the street.
If I read my newspaper correctly, we're going to see that at our next meeting, are we? 204 North Elk?
You are not. They have submitted a request for zoning board of adjustment.
Okay. I was reading the paper but didn't get the right board.
All right, any other comments on the special exception? All right, let's move on to density. This is R1 related. It's changes limiting new unoccupied STRs in R1 was a big change in 2022. And this goes back again to what we're just talking about is the 200-foot boundary in the R1s and changing that also into R2s. So is there any discussion on this?
I'm with the density that we have right now.
That's what
How about an R2?
Fine with R2 the way it is now.
So you don't want to see a change in R2?
No. At least I.
The inherent problem with R2s is that we can't use that back. I think we need to address that. So change, not necessarily trying to stamp it into. It's a very restricted group of R2s that are actually R1s. Can't live in units and properties. They're historic homes on them. Can't build the rest of it. So I understand.
So then it would be the same as it is right now. Okay?
So let me make sure I understand. Then on page 5 of the agenda packet, where the sentence reads, from the beginning, it says the biggest change in the 2022 ordinance was limiting new unoccupied STRs in R1 in an attempt to preserve neighborhoods and address negative impacts to surrounding properties. R2 properties outside the historic district still allow one STR unoccupied by right. Now comes the sentence that says a previous draft presented on June 19th did include a density limitation. Are we omitting that statement from that point forward to the end, where all it reads is the first two sentences?
Yes, because the next sentence says the current draft does not change permitted uses. If we want to consider new density, then there's suggestions.
But if we don't want to consider any, then we leave it alone,
Right.
and we take it out.
No, it's
Or we
not in,
just-
there's nothing in there. We just leave it the way it is. Because the 19th draft is not what we're.
Remember, we beat that circle down to 22, but we were advised by our then city attorney that densities were slippery road. We tried to work, but there's no real way to put a damper on it. Yeah. So that's why we went away from it. I saw it come back in again here, and I was curious.
Yeah, but who's the boss on that deal?
All right, then let's move on to condos in R3. Currently, condos require a conditional use permit. The new proposed draft prohibits any new STR condos in any zoning district. And the current draft does not address R3 multifamily housing, but we could, if we wanted to, ask for a new prohibition on STRs in R3. So does anybody have any thoughts on that?
It's page 16 of the packet, the chart. It says permitted. Well, it says
We
permitted.
have a different packet, pages.
No, I'm looking at, don't look at the right-hand number, look at the left-hand number.
No,
The tiny number down here on the bottom.
It's page
Oh,
23 in
those
the
little
packet.
It's 23 in the,
Those little numbers.
those
I
little
got you.
numbers.
Okay.
So it says in R3, permitted in STR ADU, permitted in STR B&B, permitted in STR facility, and permitted in STR occupied. I would recommend, my recommendation is that we delete all those permits and not allow any STRs in R3. Except, and then the ones that are already permitted, I think there's 5 or 7 permitted STRs in R3.
7. Yes, sir.
7, then they're non-conforming, and but no more reserve R3 for residences.
Any other comments on that?
Now, the attorney, can you defend that?
Yes, the way that we end up drafting it would probably be to allow, to the extent any single-family residences do exist in R3, they would just be permitted to operate a short-term rental, but it wouldn't be permitted in multifamily developments, which should be the bulk of R3. I don't even know if there are any single-family properties in R3.
None come to mind, but based on the Gillespie County Appraisal District data, there's 68 R3 zoned properties, parcels.
That are operating as STR?
No, total. 68 total R3 zoned parcels.
Probably half of those new ones we brought in Colorado, so.
In Friendship Lane.
It'd be nice to get a map that has all the R3. The other part of that question was condos. Okay, and the proposed draft prohibits new STR condos in any zoning district. I'm fine with that.
It is kind of a convenient place to stick them.
Pardon me?
It is kind of a convenient place to put them.
Condos?
I mean, those units, I think of those ones off of Friendship, off the back, and those don't traditionally turn into single family residences from rights footage.
Now, were those developed using the condo regime?
Yeah, so it would be simple, sold in the condo regime. And I don't know how they were developed, but they were They're mostly also STRs. Again, I'm not a fair.
Well, I think, it's like the new condos that are going to be developed by Mr. Durgan.
Yeah, didn't we just approve something a meeting or two ago and then something last night again about a condo?
Right. But then
Those condos are rentals last
we
night.
also approved, no, those were duplex.
Okay.
So Mr. Durgan stated that that they would not be used as STRs. Okay. I look at the carriage park. Those are condominiums. The issue that I see with
And they don't
condominiums,
allow them there either.
well, no, but the issue I see with condominiums is the very nature of a condominium is increased density. You're closer to your neighbor, so a potential for an STR disturbing surrounding neighbors is greater in a condo. To an extent, it's greater in a condo than it is in a single.
So that is sure. It seems like in the townhome projects and the condo projects, those are pretty much self-contained. And keeping those clean. But I'm with you on that also. Anything that takes away possibility. We should look at. Okay. So.
Okay. Transfers. Currently, transfers are allowed, must be completed within 10 days, so the 24-hour contact available information is up to date. Proposed language continues to allow transfers of including the non-conforming uses in good standing, but allows up to 90 days. And part of this is also to make it easier for staff, because the other transfers are 90 days. Anybody have any issues with that 90 days? And transfers would require new.
Is there any true cost, or should there not be a transfer fee charged to the customer for a transfer?
You have to re-inspect it.
Currently, there is no fee for transfers. They're assuming the existing permit that was already paid for by the previous owner with the same expiration date. But if that's something you're interested in, we can discuss it.
I'm
Consider
just
it.
thinking about staff and the admin portion of the transaction.
All right, just let them look into
You've
that.
got all kinds of fees attached to a mortgage.
Put that on
When
your
you go
list.
to a closing statement, I will assure you.
Yes, sir. And I can say we do have a fee for re-inspections if we have to go out multiple times. That fee is $25.
That's not enough.
All right, so 90 days okay for you?
Yeah.
All right.
No,
Inspections.
no, you didn't answer the question. Can we impose a fee, and if so, how
I don't
much?
think that that's something we talk
Not in
about.
the ordinance,
Let's let them figure that out.
Okay,
That's not part of our ordinance.
On the ordinance,
okay. But are they going to include it in the new ordinance
That
to attach a fee to that?
Right. Part of the discussion tonight is also if we go to a 2-year permit, then we would want to adjust the fee as well. So,
Okay.
Yeah.
Thank you. I'm
Okay.
thinking a budget year.
Inspections would currently require for new applications or renewals. Now we're talking about not requiring inspection during a renewal with no changes, except when there's a violation of an inspection. So that would be every 2 years. Oh, this is just inspections, not renewals. Everybody okay with the change in inspections? And then the next one is just about changing the STR regulations and requirements and what section of the code it's going to be in. And then enforcement is the last one. The draft clarifies when citations can be issued, allows permanent suspensions for failure to play hot, addresses repeat offenses, and clarifies major and minor. Does anybody have any comments or questions about those?
Any other incident in this code or civil codes where two little things equal that big thing? It seems like it's a very complicated process to get to where we're trying to get. Any other incident? I mean, you get speed twice, do you get a double speed at the end? I mean, how does that work? Maybe our attorney who drafted this up can give us an example of that.
So that is not something that you see with something like a traffic ticket, but those are set by state law. You do have the authority to create enforcement schemes that work for you, but this isn't necessarily about tickets. The enforcement structure, the so many minor violations equaling a major violation, that ties more to the revocation and suspension provisions that are contained in the ordinance. So one of the concerns that has been kind of at the forefront of this whole conversation has been, how does staff handle repeat offenders who refuse to come into compliance, who continually are bad neighbors, and continually cause nuisance-like problems in their areas? And this is what staff believes is the most effective way to address that, by creating this type of structure that kind of assigns weight to certain types of violations. And this way as well, for folks who accidentally have an occupancy issue once, they're not going to get their permit revoked for that. This structure allows them to target kind of the fundamental offenders who are continually and intentionally violating the ordinance.
Yet we don't have a grasp of what that is and company that's actually happening. So that's my argument about, let's try to keep this little simple. We're in this, it's complicated for us to figure out long-term implications of it. I just think it's complicated. It's probably going to be very complicated to interpret this with the homeowners.
Right.
So to me, 3 violations are 3 violations. You don't have to add them to make it bad.
But Jim, don't you think that some violations are more egregious than others?
Yes, they are, but to me,
I'll tell you that here I spent some time looking through my son's old Star Wars stuff because I wanted to find the Death Star. So his model of the Death Star, so I could put out there. To me, operating without a permit and not paying hotel occupancy taxes is a Death Star event.
yes.
Okay, you're out for 365 days. Don't pass go. Don't appeal to Darth Vader. You're gone. So I think what this ordinance is trying to do is to address the bad actors. And luckily, in this community, we don't have the bad actors are not the majority of the people that are operating. And I think our statistics show that. But there are bad actors. And so I see this part of the ordinance as saying, hey, bad actor, if you continue your behavior, this is what's going to happen to you. And you can choose to continue that behavior, or you can get in line. It's kind of like being a teacher, it's.
Well, the 2 you mentioned are particularly egregious, but they're also illegal. So that could be a legal action, not versus a violation action. The other ones I'm concerned about is the 3 most common ones we hear: parking, trash, and noise. Well, those are 3 of the same exact thing, as far as I'm concerned. Now, if you split it down to where you possibly get one of these violations if you're in the middle of one or not closed, that might be big. But I don't know why we need to add those 3 to make it big. So let those 3 go as 3, and when you get 3 of them, or you get 3 of the same one, then that's what the action is. So I don't really see any reason for adding them up to make it bad. Irregardless, or excluding the 2 you mentioned, because the 2 you mentioned really ought to be bring the police in and shut it down. But because that's everybody knows that's cheating the system. But the other 3 are functioning that everybody's going to experience once a year. I don't run them anymore, but I had one at one time, and I pulled up one day and the trash can was full. We'll come to find out after I screamed at all the neighbors, the neighbor across the street. So if that had happened twice, should that have added up to a big X? Probably not. So that's my thinking, that we're just complicating something that should be simple. 3 tickets, and you get an. And that's just simple.
Whether it's 3 trashes or
3 trashes or 2 trashes and a sprinkler or 3 noises and a trash. I mean, however you do it, that way we don't have to go through this matrix of making the Death Star. The Death Star is there for the 2 you mentioned because that's 2 different violation. That's not a management thing. That's a very deceitful thing. So that should be separate. So just my thoughts. I mean, I'm okay with it. It just seemed like it was a complicated process to get to and resolve. I thought the 2022 had addressed it pretty clearly. And I think the threat of it worked. But we don't really have those numbers to know if it worked or not. It might be every day they're issuing tickets for trash and water and noise. I don't know that.
But, so Jim, I was able to find the city manager's report from PD, January to July, code enforcement totals, a total of 1,060 violations, all properties. Of that, 314 were short-term rentals. Now, I don't have that broken down by trash or water, but we know those are the two primary violations across the board. As far as escalating, I mean, water violations can escalate. Ultimately you can get your water turned off. And our administrative hearing does escalate, right? So the first violation is 25 and those do escalate.
Okay.
So
you're just trying to translate this into the STR. So what you just mentioned, those numbers, though, that means that it's actually a smaller percentage of the STRs versus the overall percentage of STRs in our 6,000 residences.
And just thinking back to last year, we were looking at that closely from June of 2022 through December of 2022. If I recall correctly, around 50% of the violations had some form of STR relation.
Okay.
So that number seems to be trending down.
Okay.
Like Anna said, we're down to 30% now.
I mean, you think about it, a regular citizen and an STR owner, the STR owner has real vested interest in keeping the trash can lid down and they're watering on the right days and not making noise. Whereas the neighbor had a big giant Jimmy Buffett party this weekend, so
Yeah, but you were there. Was your party?
Okay.
So,
Any other comments on this one before we come to public hearing? All right.
cheeseburger and paradise.
So the next section, next thing we're gonna do is go into public hearing. I think we'll take a quick break. Some of y'all came in late, might not have had a chance to sign up. If y'all do want to make comments tonight and have not signed up, please go sign in, get a form and get it to Shelby or somebody. Are you taking them or who's taking them?
You
Are
have
they
to-
just, oh, they're
yes,
not
ma'am.
doing a form. Come up here and sign this form, put your name on it. And so I can call y'all to come up and speak. When we come back in, Catherine, Jeffrey, you're up, and then Anna and Smith, you're second. So y'all be ready to go as soon as we have is 5 minutes enough? We're gonna take a quick 5-minute break before we get started on the public hearing. Thank y'all.
Three A is the agenda item. 3A is whoever. Oh, is that what?
So they in this take pictures. And that's, you see, to me, I've always thought the easiest one. First time you get trash. And every single month you pay for about 10 good. So, my to borrow phone, clean up the alleyway. So that's always been good. No, that was the one that gave me changes. Well, by the way, that particular the solution that they so this yeah. I never really used TR. Now they know what I'm like. I come back on Sunday because it's another pickup. Trash my thing. I'm gone all week. It's got to go. It's got to go to say. No, you're right. Some people always, and unfortunately, Gary probably is more listening than it's probably always the week. 50% of it. 50%. I mean, I think that this was a ruckus. Everybody had a phone. That piece of thing is put on somebody's mind. Yeah. But you don't have so they don't have to have a liquor. They have broken down on the I noticed on video because my wife and I commented that he did that's one of the places yeah, well, I'll be in the public, but I got lucky that I was getting used to it. Ran like messed up my roads. And it's really like water every day. Well, getting down to our lower. Of course, it doesn't rain, it doesn't matter. Yeah, well, see here. Provided, now, I'm walking across the street. So the free church first. I don't know where I told them, but I didn't hear anybody else. Just it. I haven't heard. I mean, I get it. It's been Yep. Yeah, one of these days we're gonna get one of them scanned in. Pretty much. That's sign up. Good. Okay, everybody sit down. It's time. Okay. All right, one more time, everybody sit down. It's time to get this started again. Yes. Am I listening to them? Who are missing time?
Okay, let's get started again. We're going to get started back up. I would now entertain a motion to open the public hearing.
So moved.
A
Second.
motion by Tim, second by Jim. Any other discussion? All in favor, aye.
Aye.
All opposed? All right, we are ready to have public hearing on the proposed amendments to the city zoning code regarding short-term rentals. So, Catherine Jeffrey, you're the first one on the list. If you'd like to come up, and Anna Winsmith, you're next. All right, thank you, Anna Win. So then next would be Tom Wilson. So if you'd be ready. Okay, Catherine.
Hi. Just real quick, it's been a great meeting and I appreciate hearing the dialogue and how it works. I did want to talk about parking because I am a realtor here and I have clients who bought some land and they are going through the building process and they live in Houston and they absolutely love Fredericksburg. They love everything about our small community. They ended up buying a short-term rental that is in an R2 neighborhood that has an accessory dwelling, I guess you would call it, or a second unit. So there's two on that property. R2 has some very smaller lots, so it has 45-foot frontage. It's an old craftsman 1920s house, 2-bedroom, 2-bath, and then they have a little 1-1 in the back. They have one driveway. There's no way to widen their driveway at all. Right now, you can get permitted 2 per bedroom plus an extra 2, but they choose to only have 4 in the 2-bedroom house, so they are not permitted for 6, and then they have 2 in the little guest house. For them, they would lose the opportunity to rent to 6 people at the same time because their driveway can only have 2 stacked. So they would have to reduce their occupancy. The other thing I wanted to bring up is that people if they decide to move into that house and rent that dwelling in the back, they could not because this draft is written where the primary residence has to have 2 parking spaces and then you have to have an additional for your guest house. So that would limit a lot of people in the historic district, in the R2 district, anywhere with these narrow lots that have single driveways. They could never have the opportunity to have an on-site accessory dwelling B&B. So I would really caution and just think about, long-term repercussions. People that don't have any interest in doing a short-term rental now, but when they retire, maybe that's going to be their bread and butter, and they may want to do it then and they'll be prohibited from doing that. And then real quick, in the future, I would love it if the city could do some research on hot tax and get us some numbers. The 2018, we didn't require the permits, that kind of thing. 2022, I think that it would be interesting to see who was actually paying hot taxes in those years. If that's a thing, we could even figure out, because I think that would give us better data as to how many actual short-term rentals we had at that time. I think it makes it look like we had a very small number and we jumped huge, and we definitely did jump during COVID, no doubt about it. I was in that rush, and I know we had a lot of new people coming in, and I know they're not doing well now and they're trying to get out. So y'all just hang on. It's going to get better, in that sense. But, and then also, the panic permits, I think we have a lot of those. And so I think we have some inflated numbers there. And I think with hot tax, it would be easy for us to look and figure out how many actual panic permits we have, and then tell us how many actual short-term rentals we have in business here, just so we have
You're
accurate
actually
numbers.
3 minutes.
So, other than that, there's a lot of little things in there, like the 24-hour contact, having to either answer or be on site within an hour, I think, and have something resolved. I don't know. The police have literally told Absolute Charms on call person, we don't want you to come out, don't be on site. So you might think about that and just read the wording in there and talk to the police department about that. And the only other thing, 60 days to come into compliance with the new ordinance with contractors. Y'all know how it is here. That could be tough. So I just want to bring that up. Thank you.
Thank you.
Tom? And next would be Sticks and Stones.
Could you expand the map
You
to
pass.
cover Milam Street, North Milam? Go back down this way. Okay, so where the house is right there. Okay, so, please, yeah, sorry. Go over here. Where the house right here. Okay, we've got a non-conforming Airbnb next to us, long-term house next to us, a C1 property, meaning that there's use of property for business. And we've got businesses across the street. This is a dirt road here, not really a dirt road. It's like a place you. How do I get 75% of my property lines? I basically got to have everybody as a short-term rental next to me. Otherwise, I can't do anything. And I look at North Milam Street. Over half of the properties along North Milam from Main Street out to where I'm at are business, zoned as business, or they're zoned as mostly R1. They're about even, okay? And of the R1s, there is at least 12 short-term rentals in the R1s. There's some more short-term rentals in the business ones as well. But basically, I've got businesses across the street. I've got a business next to me. I've got a short-term rental behind me, and I've got a long-term rental next to me that has 5 cars on that curve where I can't see. I'd really like to make it a short-term rental. That's what I bought it for. I moved in to rent it, or moved in to renovate it, because I didn't get my permit transferred because I was living in it and renovating it. How am I supposed to, is there a way to make that a short-term rental with what you're saying, that 75% requirement? I'm just curious. I mean, does it mean I've got to get the person who has a business next to me to turn her business into a short-term rental? Because right now, I couldn't do it otherwise. And the other part is, what is 75% of that block? I don't know. I can't tell. Because I honestly, if you do it as if you were saying a block, it would go on behind me, because there's no real block there. So think about that when you're discussing that 75%. Thanks.
Thank you, Mr. Mason. Holly Shepherd?
My question
Thank you. Michael True.
First of all, folks, especially those at the table, thank you for your service to this community. I'm a returned son of Fredericksburg. I left here in 1990 when this town was much, much different than it is now. Returned 30 years later after retiring from the Army. And wow, I love what this place has become. And I love that I can be involved and sit in things like this and really see how this city is being shaped. But I do have some concerns, and I love the opportunity to be able to speak on it. First of all, I want you to consider, like the gentleman that was just speaking, that the gravity of what you're considering can be considered as stealing from our citizens. You're taking wealth, you're taking income, and you're taking future income and retirement. That's how grave this is. So I know, and I get it, that we have to make rules that protects the safety of our community and the overall good of our community. But every individual that you're considering taking property rights from, or you're going to take income or wealth from, must be considered individually. That's our job as public servants. So, in addition to that, and I know you guys, and I know, I get it. I'm Johnny Come Lately, right? Just got back to Fredericksburg, and I'm diving in, and I love what this place has become, and I love its traditions. I love the Sunday house culture, and I love that has continued. But we're considering complaints and issues that I haven't seen data on, and I know some board members have asked for that and haven't seen it. I don't see where public safety has been affected. I don't see where the police complaints data is. I don't see the police department represented here. I know they've been in city council meetings that we've talked, but where is that data and what's driving all these rules and regulations that add to what the staff has to do and add to the budget that the staff is going to need to track and enforce all this? You're just adding to the bureaucracy, but for what reason is what I really beg you to consider. So that's one aspect of it. The other aspect of why we're doing this doesn't have to be about the negative complaints and nuisances and noise violations. But what about the positive of it? What about these ordinances and these rules and regulations are getting us toward a shared vision of what Fredericksburg wants to be or could be? Where are those ties? Because that's much more enjoyable to talk about. That these rules and regulations are going towards this particular vision that we've collaborated on. And Mr. Mayor, yes, I'm talking to you, and I'm talking to other leaders of our community. Is that if this was pointed towards a shared vision, then it becomes a positive footing towards where we want to go instead of a negative, if you can understand that. And I'm probably running out of time, but
25 seconds left.
that's awesome. I could feel it in my bones. I heard somebody say 30% of the violations are STRs. Again, it makes STRs and small business sound really bad, but I encourage you to dig deeper into that number and find out really what are the details behind it. That's it. Thank you for your time, and again, thank you for your service and staff. I get it. Been part of a bureaucracy before to run big things, and I know it takes a lot of dedication. So
Thank you for your service.
Thank you. All right. Norman Crater and then Tim Heddleston. Is that right? Norman Crater? Did I say that right? All right. Then Tim Heddleston.
Good evening, and thank you for the opportunity to speak. I am a Fredericksburg resident, a property owner, a taxpayer, and a registered voter. I do not own or operate a business, but I am an STR owner. First, I would like to understand why we're all back here again, addressing potential further restrictions on STRs. It's been just a few months since the last amendments were enacted. As alluded to earlier, there hasn't been any analysis of or sharing of current infraction data from the police department to understand the impact of the last amendments, and yet here we are. There hasn't been enough time for city leadership, affected stakeholders, or the general public to evaluate the effects of these changes, and yet here we are again at yet another public hearing, vetting out proposed new restrictions to our property rights. Second, I would like to address some of the language in the amendment. Had you not recused the people who know better, you might have language in there that would account for the fact that when you transfer property on an STR, guests are booked out for months and months in advance. And the language now states you can't operate from the closing date until you get your permit transferred and approved. And there will already be guests scheduled to come to that property. Additionally, in section 2022, subsection C, related to transfer of ownership, it states a short-term rental permit may be transferred to a new property owner upon submission of a complete short-term rental permit application prior to commencing short-term rental operations under new ownership. I would like to remove that ambiguity and have it explicitly state that the STR permit will be transferred in perpetuity if the application timelines and conditions are met. Not only will this allow property owners to maintain their property value, provide the same opportunity to potential buyers, and provide clarity to real estate professionals in the area, it will preserve the property rights of the state and federal government guarantees me. Lastly, when I buy gas, I'm taxed so that as a driver, I pay for and reap the benefits of the roadways that I drive on. But as an STR owner, the hot taxes that I pay, the disproportionately higher property taxes that I pay, the rendition tax that I pay even though I'm not a business owner, and completely arbitrary fees for permits I'm forced to procure, and now a transfer fee, apparently, provide me absolutely no benefit. My STR uses no more of the city's resources, is no more dangerous, is no more loud, has no more cars parked out in front of it than any of my non-STR neighbors. The city sees fit, however, to grab as much of my money as possible while methodically stripping away my property rights. STR owners should not be the martyrs for the city leadership's inability to effectively manage the growth of a thriving community. Thank you again. I appreciate the time.
Perfect.
Thank you, Tim. Mike Mahoney and then Scott Zish.
And I'd also like to thank all of you for trying to make, sorry, Mike.
Your time is up.
In a flash. We're trying to make sausage out of this meat. I mean, you're boring into the details. It's difficult, and appreciate it. There's a lot of requests for data, and I think we've seen some data recently with the resident sentiment survey, the comprehensive plan survey that came out in March. It's pretty clear, while there's a very vocal group here of business owners, and they are businesses in our neighborhoods, that are present and loud. Over 75% of the people in that resident sentiment survey, 1,300 people, 75% of those who had an opinion felt like we don't need more tourists, that we're there. And I think it's not a stretch to say those same people believe that we don't need more STRs for those tourists, that we don't really want to see the increase on. We're there. So I think there is data out there. I think to rely only on the violations that have been issued is missing something. We're short a code enforcement officer and have been for months due to illness. I think we're down another one now from what I understand. So,
And I can tell you from the people that contact the neighborhood coalition, people make complaints and nothing happens. So to look at the data that actually results in violations, you're only seeing a fraction of it. So to rely on that, I think, is faulty. The network coalition, neighborhood coalition, supports restrictions in R2. We don't need more, and everyone that gets out the door is a devil getting it back. We need resident housing, and what we've got here in this this draft doesn't change a bit on resident housing. R3, good thing to stop it there, but that's such a minor impact on this town. This ordinance draft extends renewals from 1 year, as it's currently has been for a long time, to 2 years, and it has no requirement for an inspection until that property sells. So someone could sit in that property, never have a complaint file, not be paying hot taxes, have faulty safety equipment, and it never gets inspected. I don't think that it's a big burden on the city to say every 2 years when this property's up for renewal, there'll be an inspection. Some of these inspections, people have clocked the inspectors in and out of the properties in a minute. All they're doing is they're not counting 2x4s. They're not looking at beam loading. All they're doing is counting rooms and smoke detectors and those quick things they can spot. New STRs permits should not be transferable. We shouldn't continue this vicious cycle of locking those folks in to always being able to transfer, taking the ability of the city to control or affect what's going on. There is a significant correction that was misstated here too. 365, the Death Star issue. The current ordinance draft says that operating without a permit is the same as any other major violation. And failing to pay hot tax is the same as any other major violation. That's 20-224B. So it's not correct to say, right now our ordinance says you operate without a permit, you can't get a permit for 365 days. That's removed. And I really do agree with Mr. Musselman. That's a significant issue. That's not a violation of law. It's just a violation of our code. So a violation of hot tax, yeah, that's a violation of law. Thank you.
Thanks, Mike.
Thank you, Mike. Scott Zesch, and then Mark Collins after that.
Good evening, everyone. Having read both the current ordinance and the proposed, I will say I find the language in the proposed ordinance much clearer and easier to follow, and I do appreciate you taking it in that direction. I do have yet another question over parking, and I just want to make sure I understand the current draft correctly. On page 8 of the draft, I don't have the packet number, this is the actual draft. It seems to establish at the bottom, section 222, paragraph C, bottom of page 8, the general rule of 1 on-site parking space per bedroom. Just to make sure I understand, in this draft ordinance, are the terms on-site and off-street used synonymously, or is there a difference between the two terms?
Difference.
What would on-site include? Or
Good job. I'll let you answer.
Yes, so on-site would be within the property operating as a short-term rental, and then off-street would be the same concept.
okay, so it's essentially the same. Okay, and then on page 18 of the PDF, where we have the chart on minimum off-street for the unoccupied STRs, it again repeats the rule of 1 off-street parking space per bedroom, but then it also seems to establish a minimum of 2 off-street for every property. So do I understand correctly, even if it is a 1-bedroom unoccupied, it does require 2 off-street spaces?
As written, yes, I believe that requirement was pulled from the existing ordinance. Yeah,
Okay, so,
the currently effective ordinance
Mhm.
contains that minimum requirement.
okay, I didn't realize that was in the current one also. Okay, thank you.
Thank you. Mark Collins and then Joseph Brillard. Brillhart?
Hello, thank you for your service up here. I do want to agree with my Army veteran friend over here for what he said. Agree 100% with what he said. I'm a Gillespie County resident. I own property in the city and the county. I'm a builder, and I developed two condo projects, STRs, one on South Eagle, one on Highway Street. And the thing that I'm trying to get around and figure out is, why are my R2 condos considered non-conforming? I understand you have the right to, hey, we're not going to allow any more condos or SDRs, but the ones that are there, like mine, why are they now non-conforming? It just really doesn't make a sense, because they were conforming when I got the property, and all of a sudden now they're not. And the death penalty for an owner of an STR in my condos is, if they didn't renew their STR in time, is they no longer can rent it as an STR. And from what I understand, and you'll correct me if I'm wrong, they can't even sell it to someone new and they apply for an STR. That whole one bedroom, all my projects are specifically developed for STR. They're small closets. They're not for permanent residents. They don't work for that. It'd be no different than a hotel here. It has some violations, and you go to the Hampton Inn and say, hey, guy, you can't be a hotel anymore. You got to do something else because you violated something. A restaurant, they fail the health. Yeah, you can shut them down, but maybe the guy wants to sell to another operator. No, you can't sell to that. You can't be a restaurant there anymore because you violated. No one can. But that's what you're saying to SDRs. They can't operate their business anymore or sell it to someone who wants to operate it. I think that's unfair. You're picking on SDRs. It should be the same rule for every business. And if a resident, they get violations for trash or a sprinkler system, are you going to tell them you can't be living in that house anymore because you got violated? You got so many warnings. You got to treat everybody the same. And that's all I'm here for is, hey, if you're going to do this, do it to everybody. You know, do it to the restaurants, do it to the hotels, do it to the residents. If they violate 3 violations, you're out of your house, dude. You know, that's the way it's got to be. You can't just go against STRs. And I understand you have the right to limit or moratorium, no more new STRs. I don't have a problem with that. It's just the ones that are already here. They're a business. They provide a service, a place for people to come and visit and spend money in this town. You know, that's all I got to say. Thank you.
Thank you.
All right, I hope I can keep it together. I moved here in 2000, got married. I'm in this community. All my relatives are from here. I worked at the high school for many years, and I worked at a public heritage school. Couldn't make it as a teacher, not make a lot of money, so I ended up being a carpenter. So I started working for creating short-term rentals. And so after doing that for 3 years, I ended up buying my own property. I needed some investment, send my kids to A&M. Anyways, I'm enjoying that fact. In 2014, I actually had my RV. I had my STR listed with other agencies in the community. 2017, I decided to do it on my own. 2018, I'm doing mission work overseas, and my wife calls me and says, hey, the inspector's here, and you're in R1, and you have 2 different units here, and those units have to, we're going to shut you down right now. And my wife's crying on the phone. So I made it here, back, I got a permit to put my houses together with a dog trot, and therefore I was actually at that time I was actually be able to make my requirement. to have my STR. That was in 2018. The gentleman at the time that was giving permits sent me an email, said I actually had my permit. And afterwards, I'm paying my hot taxes since 2014. The next year, we're applying online, and there's faulty problems with the computer online. And so I'm told, don't worry about it. Your grandfather, don't worry about it. The next year, I still don't have an application. I still can't get my application online. So I'm telling on myself here, I'm paying my hot taxes. It's an investment for my children and for my family because I can't afford this house that I purchased actually. And I'm hoping that eventually I can move into it after it's actually paid itself off as a short-term rental. So once again, I'm vested in this community. I have family here. Maybe I'm just a different situation, but I'm still trying to get my permit. Actually, this month I have to go to court because of that violation. And I'm still, even online right now, as I put in the application and I put R1, it stops me from doing the application. So there's a problem here, and I've seen it. I'm a general contractor. I work in the community. I build people's houses. I'm in the permit department constantly. I see everyone constantly. And so I'm frustrated because I do have my investment here in this community. I'm from here. I don't live, it's not interstate, and it's not, I don't live out of town. And on top of that, the retroactive law that I'm looking at states that if it was my vision to do this property and to pay for this property as a short-term rental, I should be able to have it as long as I want and use it as long as I want. Even if I did actually start using it as a long-term rental, later I should still be able to actually still file for a short-term rental. Thank you.
Thanks, Ben.
Thank you. That was the last name on the list, but we've got a little bit of time. So is there anybody else that has decided they want to say something? All right, I will entertain a motion to close the public
I
hearing.
move we draw the public hearing back to regular session.
I have a motion by Tom, a second by Jim. Any other discussion? All in favor, aye.
Aye.
All opposed? All right, so we are at the section of this making recommendations, item number 4. And how do we best do this? Well, first let's talk. Does anybody have any other discussion now that you've heard from the public? Anything that you would like to change? Anything that was said that makes you change your mind on any of the items that we talked about earlier, or questions or comments you have about anything you've heard?
I would suggest that when we go through this, we go through the proposed ordinance by section, and then discuss the section, and then vote by section, and move to the next section. We do that.
We have legal staff, and staff have a way that they want us to make motions.
You can deliberate by going through the ordinance section by section, but we'll recommend doing one motion at the end with all proposed changes. We'll be taking notes as we go through, and then before someone makes a motion, we'll make sure that we're all on the same page.
So when we talk about each section and we come to an agreement, if we have a majority agreement on these are the things we'd like to see in that section, you'll note that?
That's correct.
Okay.
And by section, you mean the actual section 1, section 2?
The sections of the ordinance, yes. Okay.
All right, so is everybody ready to go through those? Let's go to, we need to go through that. Yeah, okay. Section 1, we don't need to go through. Section 2, is there any any changes to the definitions?
I think we need to start at the beginning.
What do you consider the beginning?
An ordinance of the city of Fredericksburg, Texas.
So
the very beginning.
The first page.
The first page.
You have changes to the first page?
Yes,
okay. Thank you all for coming.
On line 7, where it says Article 7, short-term rentals, to Chapter 20, should read of the municipal code, CODE, of the municipal code.
I mean, after chapter 20?
After to Chapter 20, after the municipal code there. Chapter 20 of the municipal code.
For the
Chapter 20 of the municipal code. Okay?
All right.
Page 2, before section 1, the last section, whereas, I recommend we delete that.
The last whereas or the
last
section after?
So that would be a legal question. Is that something that we need to?
This is typical language that we include in every zoning ordinance. It basically reiterates that the ordinance is pursuing something that is in line with what the city is statutorily authorized to pursue with the zoning ordinance. That's where the public health, safety, and welfare language comes from.
Okay.
Why are you suggesting you remove that? Sounded like a lot of frou-frou.
That's what ordinances are.
Sounded like a lot of frou-frou and didn't mean much to me. But if it's part of the code and the recommendation of our attorney, I'll take it as it.
She just admitted that it was lawyer talk. Okay,
Did you get her on tape for that? All right, thank you. That's all.
I'd just like to open this one up for discussion. The second whereas, where it's claiming that the importance of maintaining affordable housing. I could have swore we heard from our housing authority specialist or expert that this is not going to move the needle affordability wise. So I'm not too sure how this whereas got put in because it really doesn't pertain to me.
Could be a lawyer thing. Could be a lawyer thing.
Could be a lawyer thing. I don't know. I mean, I'm okay with it, but it just seems like it's an incorrect statement. As it's an incorrect whereas. We're picking whereas as the pieces. What about it's going to move the needle on short-term rental?
Jim, I think, we've been talking about housing. We've denied STR condos, if they were going to be STRs.
Right.
So it's definitely part of the large scope of things and the big picture. We're not saying this is going to solve any issue, but it's part of the rationale. I mean, trying to keep a certain level of affordable housing, especially in R3 with the multifamily. So if we're going to restrict R3, I would definitely keep that language in there.
That's a logical explanation.
All right, anything more on that section 2 then, or unless section 1, that one sentence, anybody?
I think section 1's okay.
Section 2, anybody have anything on definitions?
I just figured out when it was. I guess this is whereas number 1, 2, 3, 4, 5.
Well, you're still on whereas, it's okay.
It made reference to as well as non-resident homes. We have to differentiate. And so I'm sensitive to what Mark, somebody says we shouldn't be creating any classrooms for their stuff.
It's
So
not
you're
essential. We
suggesting
can.
Just a non-resident? Yeah, just,
I don't see where.
operators of short-term rentals in residential areas as well as non-resident owners of short-term.
This is talking about who we've listened to, and they've been in the audience, and this is saying who we've listened to. And we've listened to residents and non-residents that just own. So this is explaining who we've been listening to during this process.
That makes sense.
It makes sense.
Yes.
There are
We have
absentee
not
owners.
Yes.
We have had, not tonight, but we have.
We have a notice or protest or two from non-residents.
Okay.
So from that perspective, I concur with you.
Appreciate you.
And then
Are we done with the whereas?
I think we're done with whereas and done with section 1.
Let's get into the meat of this thing.
Yeah. Okay. Then I think
Section 2.
we approve section 1. I think we can approve approve all the deletions in section 2.
So red is adding or red is deleting?
They're
All right.
deleting.
I just want everybody to be clear of that. So we're deleting the red. Everybody have any changes on the new definitions?
which are later.
Yes,
Okay.
starting with section 3.
Section 3 in the 24-hour contact, it says the contact must respond within 20 minutes. Wasn't the 2022 wasn't that 30 minutes? Was there a problem with 30 minutes? I would think that we could give the contact more time to get there.
That's not get there, it's just respond.
Respond, right.
And if it's not resolved, then you must be there within an hour.
Okay.
Does that hour start from the call or the 30 minutes after they, or hour after they respond?
Call.
Well, I still think we should give them 30 minutes to must respond to a call within 30 minutes, not 20 minutes. Okay?
Yeah, that's what it was before. It seemed to have been working.
It was working.
But 30 minutes, okay? Okay, 30, okay.
And let's see. On page number 5, under short-term rental, are we just trying to give? We put STR in parentheses there. Do you think that everybody knows that, or is that?
It's in the title. Make sense?
Yes, sir.
Yeah. What was the
In
parentheses
the
STR?
definition of short-term rental, item number 3 on page 5 of the draft, just insert the word in parentheses STR, where it represents short-term rental. Just put it in parentheses. I think it was that way in something else previous. I think we're just trying to stay consistent.
So here's a challenge I have with the way this is crafted. This is a general statement. Under Texas law, you no longer have to pay hotel occupancy tax if someone is staying in your property for 30 days. While in most cases we're dealing with short-term rentals who are being booked during peak times and other destinations, it's very common to take short-term rental and during the off-season, say your December through January, February, et cetera, convert that into a temporary long-term rental for what we term winter Texans, people coming in here, snowbirds in other areas. So I just want to make sure that that is a legitimate use of this property. It is commonly accepted in other parts of Texas to be used that way during that time frame. Per law, they will not have to remit hotel occupancy tax if they're more than 30 days staying there consecutively. So it's really not converting it from short term because they may only be there 45, 60 days, which is a fairly common statement in Texas. I just want to make sure that we're not limiting our business owners' opportunity to do business during what is typically a low time for them to go ahead and have that.
Part of that
Part of
conversion we
that
talked about.
If
We'll
I
get to that
may,
section.
You would want to make sure that they remit a 0 receipts
Okay.
return.
Right.
That way they are always going to be able to retain that STR permit, like what we've discussed here.
I'm perfectly happy with that. I just want to make sure that by putting 30 days in there, we are not limiting our people's ability to do business, even though they'll receive a reduced rate over what they normally receive from that. Still, might be a $3,000 a month income. They would not make that short-term rental stuff. So
Yeah, that would be considered taxable.
just so the verbiage here is not limiting people's ability to do that.
In that same regard, how will we determine, or should we try to determine what the difference is between a short-term rental and a long-term rental? And to Daryl's point, if somebody wants to rent that thing for more than 30 days, which goes beyond what we consider to be a short term, we're asking people to notify the city
Correct.
that they're going to do it. What is that magic number?
It's 31 days.
31.
So if you have
31
guests
days.
staying longer than 30 days, so 31 days or more, that is a
Okay.
long-term rental. If
Okay.
they're staying 30 days or fewer, it's a short-term rental.
Okay, I just want to make sure there's a threshold there, but I wasn't sure what it was.
And to be specific, it needs to be
31 consecutive days, yeah.
Okay, all right,
Yeah,
thank
they
you.
can't come in for 3 weeks, leave.
I'm sorry,
for 3 days.
correction. Less than 30 consecutive days. So more than 30 is a long-term rental.
Okay.
Fewer than 30 is a short-term rental.
Should we
Thank
have
you.
a definition of long-term rental in here?
Yeah, February.
We do address it later in the ordinance, just briefly to allow for that, defense to permit denial, but we can define the long-term rental.
That might be a good addition to put in there, put a definition of what a long-term rental.
I would recommend leaving it very open-ended though, and just saying anything in excess of 30 days, or 30 days or more.
One other definition that I didn't see was occupant. Because of the fact we've changed an occupant not being anyone, not just those over the age of 18. Should we have it? Did I miss it?
It's on page 11, last definition at the very bottom.
Of the draft?
Yes,
Of
it does.
the
It
packet.
I
Page
apologize.
4
It
of the
doesn't say it
draft
during the other
itself.
sections. Okay, so it just says a person. So, okay. We're not going to talk about ages because it's going to be a person. Gotcha.
Thank you.
I just went over that. Okay.
All right.
Under the O's.
Um,
All right. Got anything else on definitions?
well, not on, I have something on page 6, please,
So
of the draft. Under B, permit term renewals and conditions. Under Roman numeral 5, Roman numeral 4. I think there's a typo on the last sentence of that paragraph where it references section 20-2021 and it shows to be D. And
Yeah, you're correct.
You got it?
We're fixing it.
Okay, thank you. Next one, on Roman numeral 5, we need to talk about physical permit and how we go about attaching it or making that information available to a neighbor. Because what we're talking about here is the physical permit indicating the permit number, property address, maximum occupancy, and expiration date shall be posted at or near the exterior front door of every short-term rental. Okay? The physical permit may be posted inside the front window at or near the exterior of front doors such that it is easily viewed from the exterior of the structure. What about issuing to all the STRs a BECA or a BACA sticker? Okay, why not?
So
That's all right, just answer the question.
that is a process that was never truly created. It never occurred. It was put in the ordinance and staff never developed the STR portion of that BECA program.
Why not?
It's a system that I think exists in the police department, but it's not readily used, and it's not something that our department can integrate into. They use a different system.
Is that what some type of businesses?
Yeah, I guess it is.
Yes, sir.
Okay. Here's the concern. If you're going to require somebody to have this permit on their piece of property somewhere, and you've got a problem with the neighbor, and that guy's making a bunch of noise, and you want to put that information that he needs to have, or that person that's complaining needs to have, and you want to put it where? You want to put it on the front door or close to the front door? Is that what you're saying here? So
it'd be identifiable again for police department as well, so they know, oh, this house has an occupancy of 12, and Mr. Smith is the owner, and
the point is that if you have an irate neighbor who is going to come and try to complain to somebody that's making the noise in these days and time, that is very dangerous. Because you're going to have them come up to the front door of the property and look for that sticker and that information.
it'll also be online. It is online now.
Somebody that's gonna be complaining about noise next door is not gonna go online to look for something.
So something else you could add to that placard is just put the responsible person. Most other
I mean,
STR communities.
we're talking about a security issue here where if somebody rattles on my door after dark.
Unfortunately, there's no other physical location to do it. Not a lot of signs out there.
Well, but that's coming next. I mean, if we want to do this, then maybe we allow a 2x2 sign that's some other place in this document talking about placards.
Well, I think the issue that we've got here is, number one, let's answer the question, what's the purpose of the piece of paper on the front?
To identify the property as an STR.
And part of the concern with the Becca sticker was the number of times this information is changing. So trying to maintain the correct information was problematic. So the idea is to place the basic information, that STR permit, and then if somebody wants to, provide or obtain more detail, they can now utilize this STR map, which will provide additional information. If there's an issue, you're right. We don't want people approaching that door.
Well,
So you would call it, just like any issue, we would recommend you call it in by address. And then it's up to code enforcement or PD to figure out the appropriate person to contact.
All right. Yeah. Ms. Tammy Smith called me from Absolute Charm. She was also concerned about people coming on to the property door. And I'm not even, how big is the permit? I have no clue.
8.5 by 11.
It is that big? Okay.
And my feeling is if a neighbor has a problem with an STR next to them, they're going to know who the contact person is, because it's probably not the first time they've done it. And with the online the map that the city's putting up, I tried it and clicked on it, and all the information. I clicked on a property, and all the contact information came up. So I mean, it's available. You've got it on a smartphone, or I think, isn't that correct, Amanda? You can click on something that's going to bring it. There it is, right there.
well, all I can say is that little older lady or older man than me wants to try to do this, may not be so easy.
So they'll
To
just
click
call,
on it.
They'll just call 911.
That's why I mentioned putting the contact.
Is everybody aware that this is available?
I think that's part of this. Have to be part of the city's education.
That's why I mentioned putting the contact person, whoever the 24-hour contact person is. That way, I'd be willing to bet Mike wouldn't know exactly who that person was. He's next to him. So those people would get they'd take it proactive and put it in their phone system.
Oh yeah,
I
understand that. Sure.
So if you put make the contact person more readily available, maybe that will get to the point quicker. I'm always concerned about overloading PD on these kind of deals.
I agree with not wanting to overload PD, but I think you're bringing up a personal safety issue that may lead to someone who's not properly trained in de-escalation scenarios.
Yeah. In both in Fort A and Bernie, it's required to have the contact person on the permit that's visible at the door. And it's a specific laminated 8.5 by 11 post where you have to see it. It can't be behind storm shutters, that type of stuff. So I can just walk across the street and see the phone number and contact.
Where is that?
Fort A and Bernie, both of them.
Did y'all write that, Rachel? I'm not being smart.
Not the Port A one, but we did write Bernie's, but they just adopted a new one, and I don't remember if that is still in their
I
ordinance.
just was talking to someone today about I know maybe Fort A one because I couldn't have them together. I was talking to somebody from Bernie, and they said they just made a modification where it's now that 24-hour contact number, and most of them are management companies. Most of them say Absolute. But it's just a person calling in case of emergency, and their translation was just that, in case of emergency, not necessarily a complaint. There was a fire or something, or an ambulance there. So that's just one way to maybe possibly fix it.
So what I would recommend, if you want to pursue that, is put the responsibility on the owner operator that they have to post an updated permit each time something changes. So we will issue them a digital permit. They can print it out and post it.
Perfect.
But is it feasible to put a line item on there that, because they're following the 24-hour contact person with us, and we see that.
Just trying to make it safe, and
Yeah.
if y'all can.
Well,
come up with-
and again, it was the way the Becca thing was written, you know, the responsibility was all on the city and things
Yeah.
were changing constantly. So
Okay.
we didn't know how to keep updated.
Thank you.
All right. Anything else? Transfer of ownership, next page.
Is there gonna be a grace, like that one gentleman brought up so eloquently, is there gonna be a grace period? I mean, if you close on your new home on a Friday, and, is that, everybody's, I know it's a process, and it isn't an instantaneous process either. What happens, because most of those, almost 99% of them, there's no more realtors left, they all went home, also with bookings in place. What happens on that?
So
This is ownership.
page 7.
This is ownership transfer.
Well, okay. Can I back up when you get finished with that, please?
Okay. I'm just
Go ahead.
curious, what's the procedure
Start that
gonna
first.
be?
I mean, you've got to think about it. If staff's going to have to do an inspection, I mean, there's going to be a lead time, not knowing how many permits are in the queue when they submit the transfer. Are they submitting the transfer before they buy it? Are they submitting it the day they buy it? Are they waiting?
Will you allow them to submit it before they actually close on it?
No. I don't think you can. Rachel? Can you apply for a permit for a piece of property you don't legally own?
I don't really see a problem with them initiating the application. Obviously, the permit wouldn't go through if they don't close on the property.
Oh, that's okay. That was
So, and one thing, and we did discuss this with staff a bit. When these permit transfers occur, when they have pre-existing bookings, staff does have some discretion when it comes to issuing citations. So in situations like that, staff would probably find it more appropriate to issue a notice of violation, which is just a warning saying, you know, you're not operating with a valid permit. We're not going to issue a citation because we know that you've just applied for your permit. It kind of puts them on notice that they need to continue that process and finish it up, but they're not necessarily going to be penalized for it.
I mean, because it's kind of loosey-goosey because y'all don't ever know what they close.
We don't know what we don't know, right? So until an application is filed, right, we don't know. But then we don't know if they do transfer and something happens and we don't have the right contact information. So
It was just, it kind of came up as a clerical question, probably none of us had thought of, but that is a reality of the situation. That the bookings come, that sometimes the bookings are a year in advance.
Right.
And we're trying to put a 30-day window on something. So, maybe that should be covered a little bit more.
Yeah, I concur with Jim wholeheartedly. There's a significant amount of bookings, short-term rentals, especially for property contracts, et cetera, that are often in excess of 120, 130 days or more. So they could literally have months of business on the books, and we're all telling them, oh, we have to pay for all these.
No.
Even if they intend to do it, I don't think that's actually.
So, and the other thing is, right now, to get a permit, you got to go through planning. I was the planning permit dude, so I don't know about the regular process. So you got to go through the grant system, or is it internal?
well, we're switching programs. Today it's still through Granicus, but we are in the process of getting our new system. So maybe we could have language about if you've at least submitted your application. I mean, I don't think we just let them off the hook. I mean, the point is you're transferring and somebody's got to be responsible for HOT, for the occupants. And so maybe there's language about if you've at least applied. And maybe you haven't passed your inspection yet, maybe because of scheduling. But we don't want the owners to, to be on the city, if
What is section 6.110?
That's the that's the non-conforming section of the zoning ordinance. It references residential and commercial. Essentially, it says that a legal non-conforming use that's established on a residential property can operate that way indefinitely, as long as it continues to operate and doesn't quit operating longer than 90 days. That's what I'm trying to say.
And the purpose of that is to essentially apply the same non-conforming use regulations that apply to every other non-conforming use in any zoning district. So they'll be treated just like other properties.
Then should we put, maybe in parentheses, something that identifies that section, like non-conforming use, the municipal section on non-conforming use?
Just add the verbiage for
Add the verbiage.
non-conforming. Problem that all of us that are not legal experts don't understand is if you reference something we can't see or understand, you might as well not put it there. X, Y, or Z, take a look at that. Or section 6.110, well, okay. But I'm not going to go to that code necessarily. I may have to comply. But just at least give me an idea what you're talking about.
So subsection 2 in that on page 7 under Roman numeral 2 subsection 2, it does say within the time period for voluntary discontinuance of a non-conforming use identified in section 6.110. Is that good enough, or would you like there to be a parenthetical stating the title of that particular section?
If that's what he's asking.
Yeah.
Huh? We want the title of 6.1, just even in parentheses,
Yeah.
Rachel, will help.
Okay.
I think.
All right, anything else on that section?
Yes. May I please go back to before our public comment? I said something about a transfer fee. Is there any appetite in the room for something like that?
Should just be the cost of the new permit.
Or transfer, well, it's not okay, I guess you gotta help us with when somebody transfers a permit, what's involved? Is a transfer of permit as complicated as a new permit?
No. A transfer is updating ownership information,
Okay.
local contact information, and it requires an inspection. So the process is very similar.
Okay, so could we include something like cost of
Do they have to pay, excuse me, do they have to pay for the inspection?
No, sir, not unless they fail their first inspection.
That's from the inspection. No.
Well, the issue I see here is that it's taking up city staff time, and it's a cost. And so I think that since it is a transfer of ownership, there should be the city should get some kind of remuneration to like 50% of the 50% of the permit fee or something.
In the advertising world, we call that scope creep, whereby you've been contracted to provide a certain amount of services. You have to provide additional services. You either charge for that service as reading. So it is costing the city to do that.
So what Daryl said, plus.
So that doesn't go in the ordinance, though, right? Is that
I don't.
That's a fee.
That's something that y'all need to discuss at the staff level, right? Or does that go in the ordinance?
We're working on this. We have a separate fee ordinance that we're amending. So if you go to the 2-year permit, we're going to adjust that fee based on.
And so that's
and it can't be made up fee. It has to cover our expenses.
Yeah, that's not anything that will be in any of our motions tonight. We're just saying it's something y'all should consider.
One of the issues here is that it takes up when you transfer something. This is a legal document, and you're asking the city to change the legal documents. There are costs involved in that from the city.
Okay.
I guess the question begs, what is the precedence? Do we charge a whole another meter fee to put a new meter in? Change meters? Do we charge? Look at the precedence. We probably separate the fee system and follow that.
I think staff can take care of that. We've given our recommendation. Let's move on.
Okay. That's fine. Thank you.
General comment, Madam Chair.
Uh-huh.
Thanks to all of you who are still here. I know it's only a handful of you, but we had a lot of people who seem to feel a lot of passion, yet they don't have the passion to stay to leave at 8 o'clock.
And we didn't even tell you.
No, Tim, we're going to talk slower.
Y'all get leftover pizza and cookies if you stay till the end. Or even now, if you want cookies or pizza.
Janice, don't bribe them.
No, they're here. They can have pizza and cookies if they want to come, or water. Okay. All right. Anybody got?
2.4. in section 4 on page 7, under 2, may obtain a vesting determination from the city manager. Can we define vesting?
We discussed that earlier, didn't we? Vesting
Well,
grandfathering.
So that is something kind of specific to how the city handles applications for non-conforming type uses. This particular paragraph is going to take care of folks who had issues maybe with Granicus or maybe with the transfer provision in the 2022 ordinance. So this is a very important paragraph for preserving those property rights, and I caution you to avoid changing that.
So this would address like the gentleman who said he had to turn his into a dog trot because of the issues from 2018.
Yes.
That would then allow City Manager Bailey to make that, allow him to present an argument and make the determination that he does is indeed.
Right. If he has filed an application before the effective date of this ordinance, then we'll consider his particular circumstances, and make sure that his property rights are preserved.
Right, so that means that if somebody comes in, they open their STR sale to a 2018 ordinance, and then it goes to Anna's office and she makes a determination, you're vested under the 2018 ordinance.
That's how it would work in that particular circumstance.
Okay.
It's very dependent on facts and each
Right.
particular situation.
just so long as we all understand that there's a difference for what the term means,
So-
at least we can explain it.
Right, and so, because we've got 3 different ordinances, we've got some people are gonna be under the 18 ordinance, some are gonna be under the 22 ordinance, and now some are gonna be under the 23 ordinance. And some people would say, well, I'm vested under the 18 ordinance, and we say, yeah, you're vested under the 18 ordinance as long as you adhere to all the rules in the 18 ordinance. And if you don't, then you have to be vested in the 23 ordinance.
Is that correct?
Is that correct?
That's kind of one of the things that we're getting some guidance from you all on tonight. Like as
Now,
Anna
come on.
discussed earlier in her presentation, one of the questions that we have for you all is if you want life safety regulations to be applied uniformly to all short-term rentals, regardless of what ordinance they receive their permit application under. So that answer could vary depending on how this evening goes.
Yeah, so as we go through these sections, we need to talk.
Okay, all right.
All right, anything else past inspections? I got anything on inspections?
Could you explain on page 8 under the subheading 3 at the top, when complaints are filed regarding property conditions related to health and safety concerns? So what do we mean there?
So for example, we've had complaints from occupants who have stayed at a B&B
Okay.
and found something,
Bed bugs,
yeah, or, oh, there wasn't a smoke detector,
rats,
So if we hear of something that's in the life safety section,
Okay.
that we could then require an inspection.
So where is the life and safety section defined?
We're getting there. It's on the next page, Mr. Blue. After regulations. Let's look at regulations, unless you have something under inspections. Anybody done?
Yeah, it's under page 9, probably.
Page
under
8.
page 9.
So anybody have anything on regulations? Rental period?
Just about the parking restrictions in C, about the multiple vehicles
And
the parking
is
for
Okay.
multiple vehicles.
So occupancy, we need to discuss, about, non-compliance and whether they have to come in compliance of that when they renew.
Can we do that legally?
Yes. I'm sorry. Please answer that for me.
So this is one of the areas that we'd like some guidance on. Occupancy can be a safety issue since it affects how people are able to evacuate in an emergency. So it can be a life safety issue, and if you want to impose that requirement uniformly across all short-term rentals, then that is an option. We have drafted a special exception to allow an occupancy in excess of that maximum so that if a short-term rental wishes to operate at a higher capacity because it has that capability, then that application could be considered on a case-by-case basis by the Zoning Board of Adjustment to determine if it's appropriate in that particular situation.
We're gonna keep them busy.
Okay, go ahead.
Okay, so I'm okay with that.
Just want to be,
Okay with that.
want to be consistent from one,
Right.
one part to the
So
other.
in this case, if we leave it the way it is, we're saying that whenever anybody has a renewal to come up with, if they have right now more than 12, then they're gonna have to go for an exception to continue in that with more than 12.
Correct. They would need a special exception to operate with more than 12.
If you want to apply the occupancy requirement uniformly, then yes.
And as a reminder, that's 23 properties.
Oh no, there's 48 over 10.
Yes, ma'am. It's 23 properties that have an occupancy greater than 12.
What about over 14?
11.
11? It cuts it in half. It really is, unless there's 7 bathrooms. So the only thing I'm thinking of is 14 is this, how many line buses?
Well, it depends how big the limo is, Jerome. Come on now. You ought to know that.
I think this is probably gonna be the one we're gonna get the most rub on, probably the most typical lawsuit. But our previous legal team of one helped us craft this 2022 ordinance to try to keep us out of legal problems, but apparently you guys are great. So, I mean, that's why we never really put an occupancy capacity. That's why we put that one plus. I'm perfectly fine with 12. I think that's what people want. So, anybody else have?
So you're okay with that, and then those 23 people just need to be, who would have to notify them in
Well,
advance so that they know in advance of theirs expiring that they have to have a special exception so they're not in non-compliance if they have bookings.
I sway toward the more natural attrition, and wipe those big ones out. But I mean, this is probably going to be the boldest thing we may do tonight is drop this 23 units down to 12 in the license.
Unless they have the right to go.
They have the right
for a
to go
special
to
exception.
ZBA, right?
They can go to ZBA.
Okay, I don't like any of those ZBA people, so that's fine.
They do have a path to a remedy that allows them to continue on.
That's right.
But they must, I assume, show some type of justifiable cause to operate at such a size.
Well, they've always done it before.
And the point is, we don't know if they're operating at that level. We just know that they
Permitted.
have permitted for that
Well,
level.
and we throw the whole parking thing on it too, that may throw changes out.
So this would actually help us find out how many they're actually operating at. I mean, they might be permitted 20 or 19 or 14, but only really operating at 12.
You'll see a lot if you go through Airbnb listings where they'll say they sleep 19 people, but 7 of those 19 are going to be on hideaway beds, and that's happening. Well, yeah. So
Garrett, you turned up your nose. It's missing something.
How do we come up with 12 cap?
You have something to add?
No,
Okay, I'm
that's
sorry.
okay. Again, parking, I think, is the big concern now.
yeah, I think parking is going to throw a bigger kink on it.
Because that could be 12 cars.
You know,
So y'all are okay leaving it that when they renew, they have to come up for a special exception if they want more than 12?
Yes.
All right, so we'll leave it as written.
That's right.
Madam Chairwoman, may we back up to A?
Yes, ma'am.
I would like to make sure that long-term rental is correctly and consistently defined. I recommend that we change 30 days to 30 consecutive days or more.
and what page is that on?
That is on page 8, section 2A.
Right up above that one.
222A.
Yeah.
Thank you.
So just make sure everybody's clear, because I know there's a lot of people still watching this tonight. So at the end of anyone's permit currently in place, this will be the very first move that we make that changes the vested grandfathering to 12 people versus what's now, which was, I always thought that was a very liberal move, 2 plus 2 plus 2.
But it was capped at 5 bedrooms plus 2, which age is 12.
But why did we end up with, because those are not compliant.
Well, it's because they were vested under a time period when it was by square footage of.
Okay, that makes sense. That makes sense. Okay.
And some of those bigger ones have, from when I've talked to some of them, are not even booking that many because they don't like what they do with their properties. It might not be an issue. We'll find out when they renew. Okay. All right. So we've got A corrected. B we're going to leave as is. Parking. Okay. 1 on-site spot per bedroom.
Hang on, we just back up on the 12. One real quick question. That doesn't apply for facilities. That is just single family R1 or 2.
It's per unit. The
Per unit. So
occupancy
a
is set
facility
per
would be
unit.
5 units or 6 units. Okay, perfect. I just want to make sure clear. 60 people there. People with 60 people there.
In the first conversation, I think Mr. Dooley had talked about the duration of the rental period, so that adding language about hot remittance every quarter, getting a renewal, staying up to date on inspections, right? We had talked about that. Is that where you wanted to add this language?
On which section, please?
Definition of a rental period. This
Yeah,
is
it's
where
in
we first kind of talk about long-term versus short-term.
Okay.
I don't know if we need to add that here or if it's somewhere else.
Under what section would
Well,
we?
you had asked,
Sorry, section
you had asked
20-222.
for a definition of that when we talked about the rental. She's wanting to know if this is the section where you had that change. It's not.
I would probably recommend adding it in the other section because that's what lays out the requirements for notifying staff, and that way we'll just keep
Okay,
everything.
so that's probably later. Okay.
I had it in section, you're talking about the short-term and long-term differential?
Yes.
I had it on page 14 in section 4,
Okay.
D,
We'll go there then.
where I had it.
Got a ways to go. All right, parking restrictions.
The top of page 9.
Did we add that for multiple vehicles at the bottom? I'm gonna beat that to death until I either exit or check it. On the bottom of the page, on page 8, about tandem parking is permitted for multiple vehicles.
Except that that's on the top of page 9.
All right. Okay. Page is wrong.
We've got the same one. So tandem parking is permitted for cross out a maximum depth of 2 vehicles and just insert tandem parking is permitted for multiple vehicles as long as no part of any parked vehicle obstructs the public right of way. Okay.
12, 6. That's 123 feet.
So do we know how many? We heard one person here, and Tammy Smith said that she had several other properties. It could be the same ones that she was talking about because she's from Absolute Charm, but she had some others that we're not going to be able to rent out under these guidelines. Now, this might change it with I don't know how long the driveways were, but these were the small 2-bedroom units that she said would not be sellable because they're the small ones that everybody wouldn't buy as a home.
So
that are perfect for that, but they would not meet the requirements if they can't use
So
all.
Carol, I have a question for you, Carol. On setbacks, can a driveway, the normal setback between property lines is 5 feet?
Well, again, those are building setbacks.
Okay.
So the driveway could be placed in that
So
setback.
the driveway, you could put a driveway almost up to your property line, right?
Correct. Again, we look at spacing between proposed and existing driveways. You know, we don't want driveways to butt up against each other. But again, the main question with parking is, do you want to apply this to all of them or allow the existing non-conforming to proceed and as they are? Because going back to 2018, like was mentioned earlier, those were only required to provide 1 space per unit.
Gotcha. So
Let's not forget our one bedroom STRs though, where we're not requiring them to have 2 spaces.
In 2022.
And that's for unoccupied.
Unoccupied.
Like any residence, any new residence has a minimum of 2.
By
Any
residential
single.
code,
Do you know what code that's out of? Is that the building code?
That is that'd be the NIC, yeah. Well, I don't know, that's an apartment building, so that's here.
But yes, a single family residence, a new single family residence is required to have 2 parking spaces.
even if it just has 1 bedroom.
Yes, sir.
All right.
Tammy, done an analysis on that, the 1 and 2 bedroom, affect 454.
In addition, staff did a little bit of research, and what we could envision, the biggest concern would be those STR facility properties, the lots that had multiple units on one lot. And of those, we identified 48 just in R2 that would have potentially that scenario of they're sharing parking spaces. Realistically, under the non-conforming ordinance of 18 at 1 parking space per unit, so maybe 5 units, maybe they're 2 bedroom, and they only have to provide 5 parking spaces.
So what do you do with the facility? Is there any way that they could come in conformance? If we change it?
Well, the other thing too is that we're only upping the numbers to allow them to put more on, not requiring them to put more on, not restricting them from parking in the front, because we let everybody in the world park. So,
If not on the street anymore.
No, they can park there. They just can't count it in their numbers.
just can't. So that's where it's friction. I don't know, man, that's a tough one.
You're saying 400 of them would not be able to come in compliance?
She said there's 400 combined.
They would not be able to
Two
be.
bedroom, means it's new.
Okay, then wouldn't they go to ZBA for a special?
No, but that's a.
They all just resign
I mean,
because
that's
they're
a
online.
physical-
They're writing out their
We're
letters.
gonna send you back there. So if the physical requirement is, I mean, I know just directly across the street from me, it's an old 1940s bungalow, it had no strip parking. Pulled right up to a garage, and that's. So that's, and we're starting to write a whole bunch of them. But sound in on this.
Quiet over there, Rachel.
Well, it is a difficult question, and this is one of the areas that we need guidance from you all on. This is one of those decisions that it's a policy decision. We can't make it for you. I think you can consider the burden that it's going to put on existing property owners. You can decide to not apply the parking requirements to the existing STR properties that are currently operating. One thing that has come up with staff is that a lot of the issues that residents express concerns with are parking. So, that raises the question of whether we would address those concerns adequately. But it is an option to basically grandfather in all of those existing short-term rentals parking allowances, with the exception of the on-street credit. We're still removing the credit, but they'll technically be able to park on the street.
I mean,
Yeah. I just have a tough time
I mean,
changing
there's
it to
your
that
taking.
extent.
Yeah.
Because
There's your taking right there.
right,
Yeah, you're
that is
taking a lot.
definitely taking. But if we waffle on this, then let's call back that young couple at the restaurant last night. Told them to have the restaurant. They had the parking they required.
They had the minimum part.
But they also had 25% of the circled area. Protesting it,
Yeah.
and that means we could have passed it, they would have had to decide on that. But we promised ourselves we're not going to volley stuff back to the mayor. So, I agree with your points.
You told me earlier you couldn't hear what I was saying.
We use that as our main reason for saying last night we weren't going to do it. Absolutely. And I have a real issue if we as an entity are going to sit here and make a decision one night. And well, I have to say 26 hours later now, we change and make a decision that's counter to that. And say, well, you know what, we were just kidding. Park wherever the hell you want to. especially when our residents have shown and consistently stated that parking of short-term rentals is an issue. And one thing I also want to address, and I'm going to say this now, Mr. Chair, you know, that before at one of these meetings where we had a joint meeting with the council and the PNC, the statement was made, where are all the people in opposition to this? I will tell you that in our booklets tonight, there are significant letters, not only in opposition, and they are protesting this, but they're not protesting it because we are putting new ordinances on. They are protesting because we are not putting restrictive enough ordinances on. They want to see a significant, if you read through those and realize what the majority of them wrote out what they're protesting, the written protests we received are that this proposed ordinance is not restrictive enough for residents. That's a lot of residents with 78624 mailing addresses.
The difference I see here is this parking restriction change is affecting 400 people, not one who's making application. And a lot more dollars in revenue.
I don't disagree with that.
Yeah.
I'm just making a statement that, you know, from my mind, I'm going to be consistent in something. I do not want to be perceived as a hypocrite. One night voted against something for a fairly singular reason, and turning around the next night and saying, you know what, we were just kidding. We're going to vote for this. So,
And just one quick point of clarification. That was a change of use last night. So that was a new use for the property. But I just wanted to.
I don't disagree with anything y'all are saying. Those are all very valid points. That was a CUP. But also, you know, you can look at it, if you look at it from a single item, then we're inconsistent.
If you all would like to fully discuss the legal implications of deciding either way on the parking requirement, it could be a good conversation for executive session if you want to go into that further.
I have no desire to have the conversation in executive session. Anything we say should be said in front of everyone sitting here, because the decisions we make tonight should not be made in a vacuum where people don't care rational. We are public officials appointed by the city. We need to be open and candid with the people who we supposedly represent.
So is there a way for us to... Daryl, I agree with you, but I also think that we've got to take into consideration there are geographical constraints on some of these properties that we have no control over. And there was no control over the geographic constraints of how they were built, the way driveways were constructed, how close the properties were. So we have to come up with some way of ameliorating those problems, or we just apply one rule that says, well, because we can't find a way to ameliorate your problem in this one bedroom house, then you're gonna have to go out of business.
Well, the other option you hit around the head though, Tom, is that we could possibly not make this rule apply to the thing we really would like to see in this town, and that's a 2-1 or 2-2, but nothing over that. So we could possibly put this number on 2 and above. Split hairs, but it kind of eliminates the one challenge. The one thing we're all here worrying about is
parking.
Yeah,
so we could say the parking rate that the
2 1s.
Yeah. There are no parking requirements. No parking requirements for 2-bedroom, 1-bath houses where all over town, or most of these in the historic district, or these properties R2 in the historic district.
Just kind of come up with an option. So
yeah, well, I mean that's a good option. I mean
that way it takes
it protects and allows the people that have no opportunity to cure their problem.
Yeah,
these ordinances.
Or the other option is give them a timeline on it.
Well,
I mean, if
some
we
are impossible.
Some you can't. You know, how do you create more driveway in an area where there's not the possibility of creating a driveway?
Professionally speaking, the biggest problem I have my whole career has been parking. It doesn't matter what the project is, commercial, residential, any of that. Parking is the biggest problem. And that's not across the board either. And that's kind of what you're saying is that there's conditions that are different from every project. And this doesn't always address that.
So could we have something that says parking regulations will not apply to units that are, or to houses that are 2-bedroom, 1 bath?
The square footage of the house,
Or put
as options.
below, what's a typical 2-1, or what's a typical 1-1?
Are you talking about new or just renewing? Because big picture, what do we get out of it? Okay, if we implement this stringent parking requirement, what do we gain? Are you trying to reduce occupancy? Are you trying to reduce the number of permits through a forced attrition? Because I think that's going to trigger the new state bill if it is punching them out of their non-conforming status.
That's what this looks like. It's
I'm not going to achieve that. That's natural
The
attrition.
new one,
It's going to take that.
the new
Everybody's
one's
gonna
trying to
take the
punch
beating.
him
I'm
out
not
of
gonna
not
force beating. But new, definitely new.
It would be definitely new, but not old, because the way it's written right now, you're forcing the 1-1s out of the market.
Do you want to give or do you want to go to court? Because that is where your lawsuits will come from. Immediately. You step on 400 some odd people at one time, yeah, there's your class action.
Just can you think of the ripple effects we see on property values and everything? And suddenly 400. Yeah.
Yeah.
I mean, that would be. Not to dispute your number, sir, and where it came from, but we've already had discussions tonight about numbers that were put out by the police department, and there were comments about those numbers. I would encourage city staff or someone to verify that 400 number. If we are indeed impacting 400 or 450 businesses, I'm not willing to do that. I'm not.
And also back to how many compliance issues have actually been working. Yeah. We know that's an issue, and that's a hot button issue. Everybody keeps repeating it to us, but
it's the big ones.
Yeah,
it's not the little ones.
It might be one of those things that makes it easier for us to make a decision. Because I'm very not comfortable making it on this.
So is it possible to have this drill it down, and if it is, how would it have to be stated to be enforceable? Or
The existing small ones are the issue, because they can't come in.
We can get very specific with our drafting, but I would want to work closely with staff to make sure that whatever we do draft is manageable for them to enforce.
So this is all going to be difficult to enforce. How do you know that the neighbor across the street can park his? I mean, that's what happens in my house. The guy across the street parks his big old giant truck and trailer in front of my house. He just can't fit it. So this could be a difficult one to enforce unless we go to the fair road sticker that says I'm a resident. But again, this is the one that impacts. And I don't know if this can be considered a health and safety issue except for the fire truck getting in, but he should go fly right to it. So I don't know if life safety issue can fall in this category and become wrong.
It can be a life safety issue, but it just depends on the streets. It depends on the layout. If the streets are so narrow that no one should be parking on the street, that's a different story.
So under life safety, on page 9, we're ready to move.
Well, we need to make a decision. So we're saying here we'd like to see the parking restrictions
better drilled down.
Better drilled down so that the non-conforming does not apply when permits are renewed on the smaller properties.
Existing permits.
Right. On the smaller properties, but you're saying on the larger properties you want them to come into compliance.
Faster.
Well, they can come into compliance by reducing the price.
Actually, exactly.
And you want to change the permitted for a maximum depth, not a maximum depth of 2 vehicles.
Multiple vehicles.
If you change that ordinance, you're allowed park. What happens that property? Are they different within that?
It'll be the same regulations apply.
Right.
That exemption should carry forward with the permit or with the property, I think. Is that correct, Rachel?
That is how it would work in practice, yes.
Okay, thank you.
It really isn't gonna end up not being an exemption, it's just.
Yeah, okay.
All right, everybody, we've got a ways to go. Do y'all need a break?
All right. No, we're good.
Keep going. All right.
So what did we decide on that?
We are going to,
You
they're
gotta do
gonna
homework.
drill
Staff's
down
gonna
on,
do.
how they would word it as far as the smaller properties being exempted from the non-conforming, from having to come into conformance,
Right.
reconforming.
To
when they
maintain
get
their
a new-
non-conforming.
Yeah, when they get a new permit.
We are going to need a specific recommendation from you tonight, though. So whether that's recommending disapproval of this particular section or recommending approval with certain changes, we have to have something on the books for that motion.
So we can be vague and say that we don't approve it as written, or we approve it as written, except, no, you the best way to say it. Which,
We
would
can
you
strike-
rather us not
we can-
approve it and, or have it as changes?
We can strike.
You could approve it as written with recommended changes to ease the burden on 1 and 2 bedroom properties. That would be probably the vaguest way we could approach it.
Write that down.
Or we can strike the whole issue.
Yeah.
If I may,
Yes.
there are parking requirements for all land uses, short-term rentals, single-family residential, multifamily residential, and specifically multifamily residential is broken down by bedrooms. Short-term rental is also broken down by bedrooms. I fear we're not being consistent if we allow an exception for short-term rentals of a 1 or 2 bedroom nature, but we require it for your multifamily or single-family users.
One bedroom apartments.
Point is, we allowed it. Now to disallow it, we're taking. That's the point.
And most of those projects you discussed all came in after we actually had those. Most of these little cabanas were built in the 30s and we got those in the 80s. So, I mean, we weren't, if somebody would move in tomorrow with a 2-bedroom house with 2 adults and 3 kids, basically all those 3 kids are gonna have cars. They just live in it. We're gonna make them put in 5 parking spots.
Or to Garrett's point earlier, as properties change use, they have to come into compliance with parking regulations. It's a requirement.
Right. And I'm perfectly fine with that. And as it's written now, that should be forward. I'm just worried about the impact.
Yes, sir.
Again, that would be an unequal enforcement of it. Again, my perfect scenario is family of 2, 3 kids. They're all going to get Suburbans eventually because the parents are on the road. There's going to be 5 vehicles in that same scenario, and then you'll be allowing in one.
Is this
Yes,
family of 5 living in a 2-bedroom house?
I have 3 rentals that are they're not all driving yet, but they're all little.
Okay, do you feel like we have given direction on that one?
Is that enough direction to get her point? Probably not.
If that's what you want to do, then yes. If we want to, and eventually our motion recommend approval with changes to reduce the burden on 1 and 2 bedroom short-term rental properties, is that
So when you say change the burden, we're saying just simply not applying a parking minimum on those 2?
we intentionally left that motion very vague so that we can basically look at the data, drill down like you asked us to, and then kind of approach it that way.
So with that
And then
wording,
you
you can go to mayor and city council, not having to come circle back on those.
Yes.
All right, let's go on to life safety. Anybody have anything on that at this time?
Yeah, excuse me for wanting to go back to this, but I just want to make a comment. I'm having a hard time wrapping my head around. Okay, we've decided that yes, it's a large number of these smaller ones that we're going to disavow what we were going to do as far as parking. But we've also just told anybody that's 13 or larger, tough, you're done, you're done.
No, they can give an exception.
So they give an exception, or they can reduce their occupancy. Okay. As long as we're giving some sort of relief, we're not penalizing one and allowing the other to effectively have carte blanche. Yeah, I mean, the easiest is reduce the occupancy, and technically the 2 ones can do that also. Absolutely can't do it. That's 2 parking spaces. And those live in these small bungalows that are all on strange streets. And those are those other ones. Yeah, that was one of the streets there.
All right, life safety.
4 under D, An evacuation plan shall be posted in each bedroom. So the question I have is, who creates the evacuation? And um, is it defined or is it approved by the fire marshal?
We have a sample, isn't there a sample floating around? I see the same ones in every house. So.
Well, no, you haven't, because new houses, they're the same. They've all got to
No,
be.
but I mean the same format. It's 8.5
Well,
with the red line.
yeah, or doctor's offices or
So
anything else.
who does that?
The applicant drafts a floor plan that they provide to staff. In most cases, the applicant uses the floor plan as their evacuation plan.
And then the staff approve that? Who approves it?
The inspector approves it.
Yes, sir.
The
The
inspector.
staff reviews it as part of their application, and the inspector approves it as part of the inspection.
And most of the rental companies are doing it for them.
Okay.
I'm not too sure why this became a line item for homes with gas utilities and then carbon monoxide detection for a level. Isn't that already in our standard code? Because it's actually not one in our standard code. So we're applying lesser code for this into.
We can bring it into line with the existing building code if you prefer.
Are all three of these, this working smoke alarms and the fire extinguisher, are those all code too?
Well,
regular
the
homes?
only difference is now current codes state that the smoke alarms have to be interconnected.
But they also require a fire extinguisher.
Fire extinguisher is not required in normal residential, so it needs to be a line.
Mm-hmm.
It's just one of those situations where short-term rentals aren't exactly like residences in that, they're transient guests. They don't live there full time. So it's kind of our best stab at making it safer.
I think it's good.
But we can bring the carbon monoxide line item into alignment with the building code.
Just address the RC, fire and safety code, and that's
Anything else on life safety?
I have a question on E, access to basic sanitation. It says each bedroom of a residence or portion of a residence used as a short-term rental must provide interior access to a bathroom such that an occupant shall have access to a bathroom without exiting the residence regardless of whether such bathroom is private or shared. So how do I rent my Sunday house that has an exterior stairwell
To the second floor.
on the second floor to go downstairs? Because in order to go to the bathroom, I have to go out the side of the house, downstairs, and then in.
Or to the outhouse.
Yeah.
That was not in our code before, right? That was not in our ordinance before. So that's something you guys.
So is that?
So yeah, the intention of that one we have seen in other cities where developers will build essentially short-term rental properties with like campground style bathrooms where people have to leave their residence to use the restroom. So that's the intention with that, but we can remove this provision if it doesn't work for Fredericksburg.
Provision would not be historically accurate for Fredericksburg anyway. My best friend in kindergarten had to go outside to use the restroom. Literally go down the stairs and go back into the house. So,
Yeah, I'd say leave it in. I mean,
No,
take it out.
take it out.
Take it out. You take it out.
Yeah,
So,
take it out.
It's
It's not historic.
Right. Everything else on?
What about signage under F? This is the one that we were talking about a while ago with the little placards. And this says it has to be attached to the structure.
It says may erect the nameplate sign.
Which should be considered a sign exempted from certain regulations, provided that such sign is not more than 2 square feet in area and is attached to the structure.
What is that?
No,
This
This is it. This is what it
Yes,
states.
sir.
Is the food service?
And this is separate from the permit posting.
okay.
This
So
is a placard. Yeah, this
Okay.
is the name.
I go down Elk, South Creek to go home every day, and I pass a B&B, I guess an STR at the corner of, South Creek and Lee Street. And they've got their sign attached to the fence. So would that sign be legal according to that? No. So they would have to take that sign that they have hanging from a pole on the fence and put it attached to the building. So are we going to allow them to have monument signs in front, or do all signs have to be attached to the building?
Zoning, depends on if it's commercial zoning or residential, yes.
So has to be attached to the structure.
Okay, all right, that's fine. This topic for discussion.
Okay.
All right, under food service, second line, such meal shall be limited to, add the words, for example, continental style breakfast consisting of pastries provided by a licensed provider. For example, milk, cereal, etc. Don't want to leave the impression that that's all you can, in the ordinance, that that's all you can serve. For example, milk, cereal, fruit juice, etc.
You know, that's sort of strange because there's still a few like traditional full service that are serving everything.
But are they being inspected by Kelly?
Like your house is.
Well,
That's full on breakfast. I hate not the bills kind of not very good.
Actual B&Bs are operated under state law, so they're governed by state statutory requirements, Texas Administrative Code. This particular provision is identical to what's in the current 2022 ordinance. So anyone who's operating under the 2022 ordinance and offering food service would be complying with this.
Okay. So everything that's listed here is you pick it up at HEB and put it in your refrigerator. And I'm sure that everything that HEB sells is prepared by a licensed food preparation expert.
Can we put the words for example in there? Will it hurt it?
We can add that.
Okay, thank you.
Mm-hmm.
Okay, 24-hour contact, we need to change it to 30 minutes.
Right.
Okay.
30 minutes, okay. 30 minutes.
Speaking of time, Madam Chair, certain businesses close in 18 minutes.
I know. I'm sorry.
What's
You
closing in
didn't
18
prepare ahead of time. Advertising. Did have a request from Tammy Smith to say that, does this include business cards? Because she's saying, can I not give out a business card that does not have all this information?
Well, could you just the advertising here and then just say city permit number and then occupancy maximum and eliminate parking plan, house rules, and street view?
That's too much.
So this specifically regulates listings. So without including the following information on the listing. So when they're advertising their property on Airbnb, they need to include that information. This wouldn't apply to something that's not a listing, like a business card.
All right. Answers the question. What's this? I have questions on that.
That's currently from our current ordinance.
All right.
It's parallel, yeah. It's not identical. We've tweaked the language just a bit, but it's substantively similar.
Okay, host rules.
There's something in here about my favorite string lights in here, about Chapter 5, Article 15 of the code. Is that the dark skies provision? Would you please so note there, just in parentheses, dark sky.
Page
John,
10.
yeah,
Still on page 10?
Pardon me?
Still on page 10?
J3.
Yes, ma'am. Under J number, Roman numeral 3 right here. Operating exterior string and floodlights in violation of Article Chapter 5.
Dark sky, 33rd.
Okay.
All right. Then on to host rules. Anybody have anything on that?
On which one now? Host
Host rules.
Yep. I've got something on page number 11. Number 9, property cleanliness requirements. Well, and our recommendation is, comma, if any.
Exactly.
Well,
and I'm
I
saying
mean,
that,
because this is implying what the operator has to provide. Is that correct?
Or what the operator requires.
I have found that most operators are very specific in what they expect you to do prior to reporting. Strip beds, laundry, etc. Start the dishwasher. I'm assuming that's what you're speaking of in that respect.
That as well as exterior requirements like not leaving trash around the grounds, things like that.
And then maybe you ought to put, like, not leaving trash on the grounds, because property cleanliness, me automatically goes into what you're specifically trying to shoot out. So maybe let's add that.
that's waste pick requirements out here. Waste, including location of waste and Tammy did mention that same thing, if any, because she said that they don't require their people to clean up because they have to end up cleaning up after them because they don't know they've cleaned it up right.
We just add the 2 words, if any.
Yeah, that's what she said.
Fine. Thank you. And what about number 10 and 11 about flooding hazards and evacuation routes and emergency and non-emergency numbers?
What about them?
Well, house rules, okay? Like somebody said, when you go to a hotel, do they tell you what the flooding hazard is?
Well, it says hazard and evacuation routes.
Emergency siren system. I don't know that.
They have evacuation routes on hotels.
Well, they've got that, that's on your placard.
Yeah.
But they don't talk about flooding.
Does that mean just flooding evacuation route? Or
Well,
is
it
that a
says
hazard?
flooding hazards and evacuation routes. So you live at Port A, and you certainly should know that if you don't build your house on stilts, chances are one of these days it's going to get flooded.
And if a hurricane comes in, you go down this highway
So
over the bridge.
is flooding there is that just something you've had in other ordinances?
It's pretty typical to include.
Just out of curiosity, all these house rules, is that going to be something that's checked at the inspection point? When's that going to be administered? Or
Yes, sir.
on?
It's
Okay.
kept as part of the inspection.
Okay, that's probably going to take a lot of explanation on y'all's part.
Okay. All right. Okay. All right. Now this is on the hump of the owner, correct? Okay. All right. Number 12 says, notice that failure to conform to city ordinances constitutes a violation of the code for which an occupant may be cited. Okay, what are the penalties? Whatever the standard penalties are for code violations?
Right. Yeah. So those penalties would be specific to the violation, not to the short-term rental occupant. Does that distinction make sense? So we have violations. Let's see. What's a good example?
Notice
Littering.
the failure to conform to city ordinances constitutes a violation of the code.
So we're shifting it to the occupant, not the owner?
So they can be cited for violating city ordinances. The occupants can be cited if they're breaking codes while they're in the city.
Disturbing the peace.
Thank you. That is a great example.
Perfect. Fighting in the street. Perfect.
Okay.
So
all right.
And that's a minor
And
violation.
the penalties, I assume, go along with the offense, correct?
the penalties would be set by the municipal court. I don't know what they would be, and they wouldn't really be in the scope of this ordinance.
Right.
So is this just
Okay.
general
All
city
right.
ordinances, not has anything to do with what happens on the property? Or is this what they do when they're in the whole city?
If they're engaging in, for example, disorderly conduct
on
on the property in the front yard, then that's something for which they could be cited. If they're intoxicated in their front yard, that's technically public intoxication.
Okay. So what Tammy's comment was that that's already on the permit and they already have that in their rental agreement. So she found that redundant. But if you wanted them on there, she'd like a little more clarification and like for the city to write that notice so it's written in the language that y'all want. and it's the same on everybody's. Instead of everybody using different language for that notification.
We can look into that.
Sure.
I'm sure there's a point in the process where we can provide that to the applicant.
So what we currently use is an STR inspection checklist, and a lot of verbiage similar to this is provided on the checklist. Quiet hours, for example, the requirement to post that information in outdoor gathering spaces. This section 12, that exact verbiage would be provided to the applicant.
All right, anybody got anything else?
On that particular section, section L, hotel occupancy taxes, it reads, the owner and or operator of the short-term rental property shall register with the city finance department to pay hotel occupancy taxes prior to the date that the short-term rental permit application is submitted. I don't understand why they should be submitting prior to either owning the property or having their permit.
I can speak to that.
Okay.
So whether or not you're permitted, when it comes to hotel occupancy taxes, it doesn't really matter. So if you are, renting out the property and you're receiving revenue and you're charging tax on that, the tax is due regardless of whether you're permitted. So that's how that would speak to that. Does that answer your question?
If
in fact,
you're charging tax and you don't have a permit, that's a death star.
Yeah. So if you're if you're remitting hotel occupancy taxes to us, and we see that you don't have a permit, what we do is we report that to development services.
Okay.
So that's our process. If I may, I also have a recommendation to revise some of the wording on this. Presently, finance doesn't require you to register to pay hot. We link all hot to the permit, and so I would recommend changing the word register to contact.
Contact the city finance department, correct?
Yes, sir.
Okay.
So, just a question. Is it because of Granicus that we collect quarterly? What is these? Seems like it's a lot more real time, 3 days. It's locked in components. Is that just too much work?
So the hotel occupancy tax ordinance actually specifies that you are to remit basis.
Hotel occupancy ordinance at the state?
No, that's our ordinance.
Your ordinance.
Yes,
I'm just
sir.
curious why 30 days, because the state, is Airbnb and those submit 30 days.
So the state, they actually, depending on the amount of revenue that you receive.
So I'm familiar with that. I'm just curious whether 90 days came into.
Oh, well, the 90 days was written into our ordinance probably, I think the last time it was updated was in 2001. And so that's a quarterly remittance and everything. So does that help me?
Yeah. It's just that, again, you'll hate when I put another community, but a couple other communities, it's a 30-day deal. It seems like it's a lot of pressure. And also, too, it says here about submitting actual days of use, and that's normally on all the forms where it's not necessarily. And say here it says no totals. It just seems like you keep it little.
Well, I agree with that. Something that is, let me go back to what I was starting to talk about on the revenue. The state actually has it set up where you can remit quarterly or monthly, depending on the amount of revenue you bring in. Some of your larger businesses, and I'll just use like hotel motels and some of your property management companies, they may have a larger revenue number, so they are filing on a monthly basis. Okay, so then those who do not meet certain thresholds, they may file on a monthly basis because maybe they don't have receipts. But As the second part of your question, I'll apologize, I got wrapped up.
Well, the second part of the question was, I just didn't know why we did it quarterly versus monthly, since we have a 30-day tickets in this ordinance.
Right. So that was something that was decided upon back when it was last updated in 2001. I will tell you that it is on our priority list to get that updated and revised. I feel like our ordinance can be strengthened.
Is
and
that something that needs to be changed in the ordinance then?
Yes, so we would like to look at having a threshold so that we can have people over a certain threshold remit monthly, like your larger businesses, and others who do not have as much revenue.
I see, so do it like.
Remit on a monthly basis.
Which might
That'll
be
make it a
easier for
little
them
bit easier for us to like handle some of our larger remittance operators.
Rachel, can we do that now on our side, or do we have to wait?
Well, I'm just going to say that this meeting is not posted for considering changes to the hotel occupancy tax ordinance. So
Exactly.
that was about as far as I was going to let y'all go on it.
Okay.
Okay.
And
Hey, it
she's
wasn't
also
me.
speaking hotels, not only short-term rentals, it's strictly about short-term.
And then on the next one, the same thing. Why are we requesting their occupancy history? We should have that as part of the form. But is that something that we can add with? I mean, can you just add that to the form without changing your ordinance?
I'll make a note of it, and then that way we can.
So we take that part out, go about requesting the occupancy.
I will say that's not always been tracked. So
We're gonna take
That seems like that'd be.
We're gonna
easy,
take
and
that
just
out,
put the
Rachel,
numbers
M.
in there.
request for occupancy history.
And there's also a violation for that. Turn that in.
It is written just at the request of the director, so if there were a reason to do some research, it's not a requirement, just.
Especially if they have been remitted. All right, anything else, special exceptions, anybody have anything on that?
Oh, in 3, the 50% of the properties, move that, increase that to 75. One more lot line, one lot line.
That was the 200-foot radius.
200-foot radius.
But it's, we changed the other one to 75. Okay, we can do that again.
This was the one that changed.
Okay. Very good. Okay.
All right, enforcement. Bureau.
Number 2, define timely. Failure to timely remit applicable hotel occupancy tax is a violation under this ordinance.
I'm sorry. Go ahead, Janelle. That would be controlled by the hotel occupancy tax statute, or excuse me, ordinance. So that's already controlled somewhere else, and we should not create a provision that says anything different here. And it's more straightforward to leave this alone and just say timely and allow the hotel occupancy tax ordinance to control, particularly since we are looking at amending that ordinance soon.
Okay, and the 60-day and the 90-day numbers in that same subsection then stay the way they are, should stay the way they are? You recommend that? To be consistent with what you just said?
Yes. I don't see, yeah. But I don't think that there's anything in the hotel occupancy tax ordinance that would affect it, so.
We should let the hotel occupancy tax ordinance regulate.
Okay.
So we take it.
So leave that failure to remit.
Take out 2?
Yes, sir.
Thank you.
No, are we keeping, no, we keeping into or taking it out?
I think we're taking out.
We're removing 2.
Well, does the hotel occupancy tax ordinance allow for removal of a permit as it is written?
It doesn't deal specifically with the permit. However, I don't think you should be. So the hotel occupancy tax has its own set of imposing regulations, like feasibly. I mean, a few things that we're allowed to do is we can even stop a business from operating If they're not compliant, then they're out of compliance with remitting their hotel tax. We can collect interest, penalties. We can pursue the owner for the delinquent pot. We can conduct an audit at the operator owner's expense. We can even report them to the state comptroller's office.
Can or do?
We don't presently do that in every instance. Some of it is a learning curve, and then other times we recognize that there are people that deliberately violate the law.
So should we even have this in here? Is it enforcement? Should we just?
Well, this is specific to the permit, so.
So we should have failure to timely remit is a violation under this article and then stop.
If I may, I would recommend putting the verbiage in there under hotel occupancy tax, chapter 41, article 4, guidelines for timely remittance.
Well, we can just say failure to timely remit out violation under this article, and we can we can leave it in there because it's gonna result in a permit suspension. We can suspend the permit.
I mean, put this in perspective. We're already collecting only quarterly and exchange it. Talking about 90 days late. Someone can literally be half a year late.
Well, that's
before
right.
anything happens.
Exactly.
So
That's why I said 30 days.
yeah, I think that's exceptionally generous. I think it needs to stay in here, and I would even consider reducing the time frame. If you're 6 months late on paying taxes you've collected from your guests, you have an issue there.
I think the issue here is this is a way of suspending the permit.
Well, I think at that
He's
point,
just
Tom,
saying
it is
it's too
imperative
long.
the permit be
Then
suspended.
why don't we say a 90-day permit suspension if you don't pay your fees within 30 days.
Y'all all remember Helen Taylor? She went to a grave on this hospital.
30 days, I mean, you got a little bit of leeway, but I would concur with the 90-day suspension.
The only thing I think is when you're transferring, that taxes should be paid in one transfer. And you are seeing that transfer.
Okay, so to address that matter, what should be happening in a real estate transaction is the old owner and the new owner should be discussing and negotiating who is going to pay the HOT. Because what happens is if you don't negotiate that in the real estate transaction, then it automatically becomes the burden of the new owner. And they don't always have access to, all of the revenue.
Property management company may not pay it. The new person doesn't know how much they would owe.
Right.
So it
So,
needs to be in this.
yeah, so what would happen is we would automatically go back to the state and look at records on what their receipts were to the state and base our 7% on that amount and collect that from you. If we ever had to do that, we've not ever had to do that.
All right, so let's get back to number 2. Do we need to leave this in there as written? Rachel?
I'm double checking the city ordinance and the state law on the hotel occupancy tax penalties. And I don't think that we can suspend a permit under those statutes for doing this, but I think we can do it by ordinance. So it just depends on whether you all want that to be something that we can suspend a permit for.
May I ask, how would that affect, so for example, when we are in municipal court proceedings, trying to collect that pot, and if we've already taken steps to enjoin that business, as well, how would that 90-day suspension work?
I'm not sure I see a conflict with it.
Okay.
I mean, I can dig into this further. I'm not really prepared to answer that off the top of my head, but we can take a closer look at it and talk it through.
All right, so we'll leave that in here. You might
To
have anything else
Janice's
under
point,
enforcement?
are we gonna leave in
Yes.
with 90 days
Yes.
and 30 days?
Or we're gonna leave it in there. What do y'all think about the days?
I say 90 days on the suspension and 30 days on the within pay.
$90-day suspension if it's not paid within 30 days of the delinquent notice. When do they get a delinquency notice?
Timely.
Who said that?
Generally, the rule of thumb has been, so for example, this last quarter, the second quarter was due July 31st. Generally, like between the 10th and the 15th of August, we would have sent a notice.
And that's when the clock starts.
And so this last quarter, Darren sent out over 200 blanket notices.
I think the whole purpose that we're talking about here is we just want people to obey the law as written. You know, we just want them to operate, we want them to collect tax, but we also want them to pay that tax in a timely manner.
Well, I think you had a perfect example. There was one gentleman tonight stood up and used the phrase "my tax money." He is collecting that tax money from the district for Texas law.
It was never
He is
his
merely
tax.
holding it. But if he's viewing that as tax money, that is the issue that you have with people who are not taking this to the honest level and to the legal level they need to be. They're looking at, they are either uneducated or ignorant of the law. So, you know, and they are benefiting from the use of those tax dollars that are collected, generates awareness of the destination, which then instantly comes back to generate additional bookings for them. So,
All right, anybody have anything?
Being fraudulent.
I'm sorry, can I back up to special exceptions? And I just have a quick question. This has come before us as being at least 3 times that I know of, and that is the rental operation and storage shopping district on the first floor. We just add at this point in time nothing on Main Street. I mean, the ones that have been coming to us have really been Austin, San Antonio, but we just have those.
They're not coming to us. They're
Well,
going to
these
the
will
special
be.
exceptions.
These,
No,
they'll go to special
they'll
exceptions.
go
They'll
to
go
the,
to ZBA.
yeah.
Yeah.
All right.
That's your next board.
Advertisement, citation, anything else on enforcement? All right, repeat offenses, suspension, revocation, anybody have anything?
Provide occupancy history. Number 2 down at the bottom, or provide occupancy history, updated application information.
So that, if we're striking that on the other one, that should be
Yes,
struck
that is
on here.
correct.
And this was the condition I brought up earlier about the 3 citations.
Right.
Minor translate into a major.
So was this discussed with PD? Are they okay with this? Is this something you'll work with them on these violations since they're working with? Does it affect them?
So code enforcement and PD have been involved in the draft of this ordinance.
All right.
So they know, they are clear about how they're going to convert 3 minors to a major.
They're not doing it. Right.
Well, it would be a coordinated effort. You know, we'd have to also work with municipal court and the administrative hearing officer. So
Okay.
lots of tracking.
My thoughts were just don't make the conversion factor, just make violations. And that would be whatever our ordinance stated. That's it. Yeah, because it's a nuisance to our populace with the trash cans are blowing over. So this just seemed complicated. I just was trying to figure it out.
And are these the same for me if I have issues with parking or solid waste or water or elements at my house? Is it different for a home than it is for?
It's for a permit. It's tied to a permit.
Okay, gotcha. Just want to make sure.
It's not
People
their
keep
permit.
saying don't treat a home.
It's not their permit, it's the same violation.
Yes.
Right, and the violations are being treated equally. It's just that they then can
They're handled differently.
ultimately they impact your permit.
It's past 9 o'clock.
Yeah.
My brain started shutting. All right. Anybody have anything else on enforcement? All right. Appeal? Anybody have anything on appeal?
Excuse me just a minute. Go back up on page 13 of the draft on the thing about the city council on number 2, Roman numeral 2, about upon consideration of evidence presented by staff, city council may suspend the permit for 90 days. Can we change that to 365 days? And can we change it from may to shall?
I do not recommend that.
Okay.
What was that answer?
No.
No.
Right, yeah, I don't recommend that.
Yeah, I wouldn't. That's
You don't
too long.
recommend
That's a de facto permit revocation, and it's not appropriate.
Okay.
Then what
So-
about the shall, suspend for a period of 90 days?
I think leaving that discretion for city council is important, because if we've got, a series of violations that are not as egregious, then that gives council the discretion to say, okay, the circumstance is different. Maybe revocation or suspension is not appropriate, or excuse me, just suspension is not appropriate in this particular circumstance.
Will city council have a limit?
What do you mean?
Well, if we can't put 365 days in for suspension, can they do it? Can city council say 365 days?
I don't think city council, after hearing what's being talked tonight and what we're saying here is they're not going to add 365 because apparently it's illegal.
No, I think it's shall.
I think neither are advisable, and I would give council the same advice that I'm giving you.
But you're saying anything beyond 90 days.
It could go higher. I would not recommend that it go to 365. But I think 90 days is reasonable in this circumstance.
Okay.
Just gonna put it. Rachel, could it be less? Is this for up to 90 days? Or does council have the option to say 45 days?
They could,
to
yes.
review?
That is not particularly clear, so we can maybe tweak that drafting to make it clear that it's for up to 90 days. But yes.
That's their discretion.
Right.
Okay.
But yeah, put in up to, please.
All right, anything else on that section?
Yep.
All right, Neil?
All goes to ZBA, right?
No, it goes to city
No,
council for appeal.
City council.
Yeah.
All right, then, applicability to existing operations,
Whoops,
non-conforming uses.
excuse me. On D, it says a court of competent jurisdiction.
Is that municipal court or?
That would be, let's see, I believe that would be the district court.
Okay.
That's what you meant. You were talking about court and competent or
No, not
mutually exclusive.
Now, is that by statute, Rachel?
I couldn't tell you off the top of my head. I think it is by statute. It could be by just court rules, but I can double check.
Well, that's fine. All right.
So how do we handle the 20-2026, since we are picking which ones are not? What are we looking at here?
So if we're allowing grandfathering, do we need to eliminate A?
I think we need to rewrite the whole section, don't we, Rachel?
It depends on what you all want to recommend.
Well, as this is written, if this is eliminating non-compliant vesting, grandfathering, slash whatever else you would call it, then it needs to be.
Well, that's what it says.
Is not.
It's not what we've
our
talked
choice.
about all night.
Yeah. It's not our choice. Is not our
Recommendation.
rights to sunset anything at this point.
Right. So what would so for example, we discussed whether life safety regulations will be applied to all STRs that are currently operating or only to STRs that obtain a permit going forward. So that's the kind of thing that we're looking at now.
Okay, well, the life safety applies to everything, so and that applies currently. That's changed. Am I correct?
I think you need to specify that. So under A, maybe the regulations identified herein for life safety and occupancy shall apply to all. Is that a way?
That's not part of our current ordinance.
No, we're saying Right now, this ordinance says that everything has to come into compliance.
I see.
And that's
We
not what
state
we want.
otherwise. So here we're stating the ones that we don't want to come into compliance. We come into compliance at renewal, and we said occupancy. We want to come into compliance at renewal, so it's not changing. But parking, we wanted the exception for the 1 and 2
Small
bedroom.
units. And then that.
Life safety, we want to come into compliance.
Right. We're leaving R2s as a one by right.
That's in. There were just other minor changes, but that have to do with non-conformance, right? With changing. Is that what y'all have in your notes?
But that was the direction we were heading. Maybe.
Yeah. Are you thinking, Rich?
Yes, I'm making sure I know which ones that we've talked about applying uniformly. So my understanding is that life safety and occupancy you want to apply uniformly going forward to all existing and new STRs.
12 cap.
Thank you.
And the parking would be the one wouldn't. And would you have anything else?
So just make sure this is not a trap. Section C of this, it says all legal non-conforming short-term rental uses located in the zoning district or short-term rental uses no longer permitted by right shall be subject to the abandonment of non-conforming use provisions. That means basically, it doesn't mean we're abandoning them, it means when they're abandoned.
Only when they're abandoned.
Right. So they're governed by the abandonment.
Definition? I mean, abandonment by definition?
It's defined in section 6.110 of the zoning ordinance. So they would refer to that. Right. So they're subject to the same abandonment provisions that all non-conforming zoning uses are subject to. So we're not forcing them to stop anything. It's just that once they've discontinued their use for a certain period of time, then that use is considered abandoned and they lose their non-conforming rights.
Okay. That's where that was our impression.
Shelby was talking about a while ago. Okay. Thank you.
That's everybody. Never be on that. Section 4, is that just another set of definitions? Anything on 4?
Just trying to read the paragraph. Do
you have anything on section 4? Or 5?
On 5, okay, you're talking about section 5?
Yes.
The matrix about the R3 with parking?
It's permitted.
Permitted.
Where it's permitted, that goes away?
Yeah.
Is that correct?
We talked about.
Okay. That's what I have on that one.
So this is where that's going to be?
And then on number 3 on page 16 of the draft, under D3, we changed the 50% to 75% to be consistent with the last time. Page 16 of the draft. Item number 3, line 5, and more. 2, more than 50% will change to 75%.
We deleted the P's in R3.
Yes. And then we went down to the 50 in the middle of the page. Number 3, 50% will change to 75. Okay. Okay.
That's
Next page, the same thing on number 3.
Section 5's okay?
Section 5.
Okay.
Number 3 changes 50%
Right.
to 75%.
All right. So we'll finish with 5 and go into 6.
Section 6, number 3A, same thing, change from 50 to 75%. All right. Dennis, maybe go to section 7. All right. This is the one about the street, the parking.
We'll make the change to the tandem parking language and just switch all of the maximum depth of 2 vehicles to the multiple vehicles.
Correct. And from one item. Have we done this about, in no case shall the number of required off-street parking spaces be reduced below 1? That sounds stupid, but here we either take out that altogether, because aren't we working toward 1 bedroom and 1 parking spot? So we're saying here, in no case shall the number of required off-street parking spaces be reduced. So does that sentence does not apply?
Does that conflict? Does that conflict with the other code?
Residential code says you have
Residential code.
Well, I thought because we were trying to get those 1 bedrooms down to 1 parking spot,
Well,
were we not?
We're going to look at it and look at the data
Okay.
based on your recommendation tonight and see what we can do for those properties.
Okay.
The IRC.
Can you make a note then if you rule favorably in that regard, this section needs to be changed?
Right. Yes, that would happen. And just for clarification, the IRC would apply to new residential structures. It doesn't necessarily apply to residential structures that were constructed before the IRC applied. So if 2 parking spaces are required now, that may not have been the case when they were originally built. And that would be why we have these non-conforming structures.
Thank you. Okay. And then the multiple depth of the multiple vehicles depth.
Just tandem parking is allowed. Yeah.
For multiple. All right. Now here's another good one. Somebody's going to start throwing rocks. According to my list, this is all I have. How do we handle a couch in an STR?
Does anybody have anything else before Mr. Dooley goes on his couch?
I do not want to think of Mr. Dooley. That's everything in section 8.
Okay. Section 9 through 12, anybody have anything? Or 14?
No, that's everything in section 7.
Anybody have anything from 8 to 14?
And then section 8 that's the prohibition of STRs and condos, correct?
Correct. That is, we're deleting that as a permitted use.
We're okay with that.
And just to reiterate that would not affect condo STRs that are currently operating. They would be grandfathered in.
Now, Mr. Dooley's question.
All right.
Yes, sir.
This,
Thank you.
This has to do with parking as it relates to occupants and parking and a couch. If you sleep 6 people in a 3-bedroom house, you're supposed to have 3 parking spaces. That's 6 occupants. What happens, how do you class a couch
2
in an
bedrooms and a
STR
couch.
as far as occupancy is concerned?
Well, that's why we've always allowed 2 plus 2 plus. That's why we've always allowed that plus, but we're changing it.
All right, so there's the question. What do you do about a couch?
So it used to be, well, now our parking regulations have changed, so now we have used to be if you had a 2-bedroom house, you could sleep 6 people. You know, you put one of them on the couch, on the floor, on the ceiling, and then that.
All right.
You still can.
You still can, but and it's always, and the parking has always been matched with that. Okay, we're still there. Okay, and so whether it's a couch or bedroom, there's 2 bedrooms that can have 4 people plus 2. And we're still that way.
No, we're matched with bedrooms.
We're correct. So parking is based off of your bedrooms.
Parking space on the bedroom. So that 2 is
One
the same
parking
way.
space per bedroom
To
under
get-
the 2022 ordinance.
The 18 was square footage, we went to a bedroom count. Right.
This one still does not count those plus 2
Correct.
in that.
We've lost the plus 2. Have we?
No, sir. Your +2 is still in there.
It's in there.
Okay. So bedroom plus 2.
Yes, sir.
So are we accounting for parking for the plus 2?
No, sir. And we didn't in the 2022 ordinance either. It was 1 parking space per bedroom.
Okay. All right. Ask and answer. Thank you.
All right, is everybody happy with everything
So
we've done?
just to clarify, just to make sure, because like Billy mentioned to me much earlier today, that your brain loses capacity after your rear end can't sit anymore. So we have not sunsetted any.
That's correct, except condos and R3.
And so we're going forward and we're going to basically let attrition move us forward. So then my only other thing I'd like to bring up, I've been bringing it up for about a year, but it seems like it's being lost in the wall. I would like for us to now do a moratorium.
And I don't think we can.
You must have missed Mr. McCamey's
Yeah.
presentation lately.
He's not here.
But no. If he was here, he would tell you you can't do moratorium on anything.
My question was, why can't we do a moratorium starting going forward on any new ones? That's been my pitch all along. That way that way us, y'all, and everybody else now, for the guys at DPA won't have to continue seeing new projects. Or really don't want them in.
Then prohibit them. I mean, this is your chance. Where do you not want them? Do you not want them in R2?
No, he's talking about a general statement.
Any of them. A
We
moratorium on
we
any.
have 1,400 of them. I mean, that could be what's stopping us from getting affordable housing. That could be what's stopping hotel development. So we have plenty. We're not sunsetting any of them. So why do we even entertain more? And maybe make that moratorium a year and go back in a year and just reevaluate.
But then doesn't
If it can't be done, I'm fine with that. I just think it's an easy thing for us to do now and not have to continue to fight this on a regular basis.
wouldn't that contradict what we just did? We said that if
Oh, not
commercial
really.
allowed and by right.
Again, that's okay, but we can pump the brakes. Can we not?
So the 2022 ordinance did that. So since April 1st of 2022, 54 new short-term rental permits have been issued. That's it. 34 of those are STR unoccupieds. 8 of those are STR facilities. 10 are accessories and 2 are B&B.
Okay. But that's 54 there. What I'm saying is none. 0, none. Yes.
clear, laid out, walk. What are the issues that we are trying to solve? Because we've got 5,500 houses, 25% of them are talk about several of safety violations. Talk about a clear number of violations for. So we're short of this state laws and propose a time limit for it. Done the following conditions. The following. You have to be, I think, stronger. We can make the case for the housing through
Infrastructure, stress,
difficult at this point to make the case of safety law here. And promote the nuisance. Right. Public safety law and the sheer number of violations that we create having.
Okay.
We can't help.
Mayor, is that moratorium not also statutorily limited to 120 days?
Well, I said jump on that. Because I know there's projects coming down the pike. I know of them, and they're big projects, and they're the same projects we've been battling. And man, it puts a lot of stress on us because we're the first to say no, and we're saying no right now. Where I'm kind of nervous about saying.
I have research.
And I don't want to just shift it over to you guys. That's what's going to happen. Okay.
All right,
Well, I tried.
guys, are y'all ready to make a motion with the adjustments, the changes that we've made? A motion to accept it with the changes that we just
And the two
made?
caveats, the parking.
Well, those are the changes.
So will we get a look at that before it goes before council? The revised, will we get a look at where y'all land at before it goes to council?
It will not come back to this board before it goes to city council on October 3rd. It'll be made public, the draft will, and we do plan to make those revisions to send to city council, but you won't get another vote on it.
Understood.
If we find something we don't like, we call it that. We can at least say something.
Okay.
I
Is
move.
anybody ready to make a motion?
I move that we approve the draft ordinance as amended, as of record tonight. Is that enough, Rachel? Does that get it?
I think we need to be a little more specific. Give us 1 second. We're gonna figure out exactly what language we need to use.
Good. Now I'd be happy to read it.
Perfect.
We need
And of course, Madam Chair, this will be your roll call vote.
I have to wait for Mr. Thomas to come back.
Yeah, Daniel made us go back and forth.
One little word makes a difference.
Really be short.
Yeah. Except maybe.
The CPA.
Well, because they didn't. That was basic. Yeah. Any of y'all want a cookie while we're waiting? Y'all can get one.
I had way too many of them this week.
You haven't split them up?
We had them for breakfast, we had them for lunch, we had them right before church and after church.
What's that?
So that's sweet for me. I went. Texas did it for breakfast. water issues. Yeah. I don't know if you just, Jeff, oh, it wasn't a water issue, it was an electricity issue. No, it was actually just, there you have, here we buy from the city, there you can buy from me. And it was a clerical school. So fortunately, I know the city manager really, really well, and he came out and did our inspections. I had to do in my house. It was 100 degrees and we had no electricity in my trailer. It wasn't anything I did. I got it fixed as quick as I could. It's clerical. So meters have an ESID number, and someone with one ESID number off of my ESID number did not pay their bill. So the damn utility cut it off. Yeah. In Port Aransas, if a meter gets cut off, before they recut it back on, the city inspector was out concerned. So it was just off. This thing was just off. I went out there and sat at the city desk. What came in the problem? I told him the problem is changing it. He went and drove by and called our garage just to 28 hours. It cost me groceries and inventory. That's okay. I could go and forget it. One of the other little lady had been 40 years. She's the one so and her cat. Yeah. There's a lot of things I know about. I'm a firm believer in the first rule of Fight Club. Yeah. The first rule of what? First rule of Fight Club. The first rule of Fight Club is about Fight Club. Oh. Yeah, I remember it was like that one. So y'all did sunset my permit. Everybody got it figured out? My 3 permits? Yeah. Because I talked to them about it, they sent it to y'all. Well, I think it was the first quarter, yes. I didn't have any guests in the second or third quarter, so. I had clear room for all 3 of them. I had to. Had to find a place for them. There are things I can do that will. I should always do, especially in the sexual category, just the way life pose.
If there's anyone that's watching on streaming, we're not adjourned yet. We're waiting for legal counsel to draft our motion properly before we adopt it. So hang on, we'll be finished in a little bit. Okay, everybody, we're ready for the motion.
Okay. Thanks for your patience with us. So how we can do this is I'll just list off all of the recommended changes, and then whoever makes the motion can say motion to recommend approval with changes as stated by staff. Okay, sound good? I will read all of them. Yes. Okay, so the changes to the ordinance discussed tonight are.
Your time's up, Rachel.
Oh, you've got the lawyer to stop talking. Okay. All right. The changes discussed tonight include removing R3 as a permitted short-term rental use district, defining the term long-term rental and adding additional conditions for the voluntary discontinuance period of a short-term rental permit to operate as a long-term rental, adding the 24-hour contact's name and number to the physical permit posted on the short-term rental property, applying occupancy and life safety regulations uniformly to all existing and new short-term rentals, approval of the parking regulation as stated in the ordinance with additional changes to ease the burden on 1- and 2-bedroom short-term rentals, allowing multiple cars to tandem park, removing the access to basic sanitation and occupancy history requirements in the regulations section, aligning the life safety requirements with the International Building Code, changing the 24-hour contact response time to 30 minutes, amending the R1 density percentage to 75% instead of 50%, and amending the enforcement of the failure to remit hotel occupancy tax to require remittance of delinquent tax within 30 days following the issuance of a delinquency notice.
Okay, thank you, Rachel and Anna, for putting that together. Everybody hear that? Do I have a yes, sir? Mr. Musselman, I see your finger up. Oh, do we have a motion on that?
No.
Oh, they're not finished?
No, we're good.
Okay.
Okay. I move that we approve the changes as presented by our staff attorney as presented.
I have a motion by Tim and a second by Tom. Any other discussion on the motion?
Roll call vote, please.
All right.
Steve Thomas.
Yeah.
Tim Dooley.
Yes.
Tom Musselman.
Yes.
Jeff Lawrence. Recused. Daryl Whitworth,
Yes.
Jim Giroux,
Yes.
Janice Menke.
Yes. All right. Motion carries. All right. Thank y'all, staff. A lot of work's gone into this. We appreciate all the work y'all have done, and I know you're not done. Far from done yet, so thank you, and for all the work you'll still put into it before it goes to City Council. Thank you, City Council, for your work. Thank you, everyone who stayed here tonight, and those of you who stayed, oh, they're gone online anyhow. Streaming's off. I can't even do a dance form or anything,
This
but
might be a record.
this is a record.
I move we adjourn.
All right, I have a motion from Tim. Do I have a second? Nobody?
Second, I make a
Second
second.
from Jim. If we adjourn, all in favor, aye? All opposed? Let's go home. Thank y'all, everybody. We'll clean up. You're welcome.
You're welcome. Good to see you.
God, don't fall in Mr. Dooley.
Well, I don't know him like that well, but I understand.
Yeah, he does.
Thank you.
I don't know. We may have made you drop harder. Who knows? Thanks for sticking around.
Well, hell.